Good morning, everyone, and welcome back to the public hearings of the TRRC. Imam, you have the floor. If you can offer some prayers, please.
We'll have a common prayer, each one in your own tongue, as we say. And then I will conclude the prayer with the Islamic way of praying. Thank you. Bismillahirrahmanirrahim. Bismillahirrahmanirrahim. Alhamdulillahi Rabbil Alamin. Rahmanirrahim Maliki Yawmiddin. Iyyaka na'budu wa iyyaka nasta'in. Ihdina as-sirat al-mustaqim. Sirat al-ladzina an'amta alayhim ghayril maghdubi alayhim waladdallin. Alhamdulillah hadina li hadha wa ma kunna linahtadi lawla anna hadina Allahu al-awwal wal-akhir wal-zakhir wal-batin. Ya Rabbana lakal hamd. Ya Rabbana lakal hamd kama yanbahi وجلال وجهك وعظيم سلطانك وصلى الله على سيدنا محمد خاتم النبيين وإمام المرسلين بحرمة اللهم فصل وسلم وبارك على هذا النبي الكريم سيد سند العظيم ذو القلب الرحيم سيدنا محمد وعلى آله وأصحابه وسلم تسليما ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار سبحان ربك رب العزة عما يصفون وسلام على المرسلين والحمد لله رب العالمين آمين.
Amen. Shukran, Imam Jallo. Council, I believe we are continuing with Mr. Mboj from yesterday's testimony. If that is the case, you may please proceed.
Good morning, Mr. Chairman, Commissioners, and members of the audience. We are ready to proceed with yesterday's witness, Mr. Lamin K. Mboj. May he be brought in, please. Good morning, Learned Council.
Good morning, Lead Council.
Learned Council.
Good morning, Learned Council.
Welcome back to the TRRC.
Bismillah TRRC Kotange.
Thank you very much.
Numbara.
May I remind you that you are still under oath. And as you very well know, the warnings that I informed you of yesterday still apply. Could you confirm?
Thank you. I remember everything.
Yesterday, we were dealing with your personal experiences of human rights violations during the Jame era. And you have explained some of the personal experiences you had of interference with the judicial work. And you've given us several examples. Examples of magistrates giving certain decisions. The government is not happy with those decisions. And some punitive measures taken against that magistrate.
me misalo do edol min dina ja wala nyiti ko kiti bundal la kiti ndirlal melan ko lebe dumala magistrate court ika kiti o kuntu nyala nyaado me alon ko ni ya kuntu abukana dia mansa kunda e tumala men ninga atare sulo soto case nyinto abukada wala fana o kiti tela nyi magistrate o nyim fana ikana deto la kan yo misalo dinna.
You talked about your own experience in Basse, wherein you are basically transferred, or starting from Banjul, to be more precise, you were transferred from jurisdiction to jurisdiction because of unhappiness with some of the decisions that you've made.
Ye wato benum Banjul ye bondi Banjul ye samba Basse ke bondi dingira kiti bunda ro kare samba kiti bunda ro kuka me ya longo e ka kangol men kuntu ikela kiti ol kuntu nyame abukatara abuka mansa kunda men be sirinu abuke sewo wala ka sabu ke soundin dingira do kiti bunda.
One example you gave was particularly interesting.
Misal kilindi beje kilindi o misal let me ya longo ode o em sula bakele.
That is the case of the July 22nd movement people in Wuli.
July 22nd moldi men ya lonko wolle be wulli.
People like Kandakase Jawara,
Abe kono Kandakase Juwara
and others.
Anin do ko tangodu.
You then talked about a very interesting case in which you were involved in.
Nuinarna case do fam foja me ya lonko o case nyinde o nyabo warta bakal me ya lonko ita fam kunne dunda akonole.
The case of Hamadi Sow.
Case member ko Hamadi Sow la case.
That is a very interesting one.
Munye case ku diamlet me ya lonko nyabo warta bakal.
And now we started talking about the case of Pahari Jame.
Silang isa damuda hapa hari jamela ko nyi ala case nyi ngadamuda wo fanana.
And Lamin Jobate.
Lamin Jobate.
And Joguba.
Anin Joguba.
Could you proceed from there and tell us about that case? You've gone as far as telling us about the assignment of the case to Justice Inkia.
Isa damuda ka tentendu wodo ya mutawodo ya fonyela nunga haninka bi case ni wala nyimmo sabola case ni biri ya nati ya di kidi tela mena wala Justice Inkiati.
Thank you very much. That was a peculiar case. That is the case of the state against Dr. Njoguba.
Oketa kiti kaokuliti menketa Dr. Njoguba la kitoti.
Because that was the first one. That was the economic crime charge.
Atu wala mfoloti menketa banko fankatinya tumiroti.
Let's talk briefly about the economic crime law.
Silanga diamu wati sutun kono nga jube nyi fankatinya lual nyinti.
The Economic Crimes Act,
luwa membe marale nyi fankatinya kunyal.
You'd agree is in fact a revamped dress pretty much. It was a decree and it's now dressed into an act of parliament. Or an act for that matter.
Ibe sonna mala nyinna ko luwa nyi me alon ko wolbe nyi fanko kunyal to. Wamu luwa ti me alon ko ikaf me decree andu inata na yele mandi inata na dundina luwa buko nyi kono ikaf me act.
Yes, I'll agree with that.
It's
a decree that was having a double effect on the citizenry.
In fact, its provisions are pretty much antithetical to the human rights provisions of the Constitution.
Yes, I'll agree with it to an extent. That's why I said it has a double effect.
Yeah,
the first is the positive effect of preventing people from abusing their powers and offices and acting in excess.
Follow, wolem nyinti a sarto ala lodula bijele men se molu bali kuruya ke wala ka lanna tambo ke office kono ka fanko tinya anin ka kolu ke men ya lon ko ni sarto manta nyola se molu bali wala.
But even at that, Mr. Mboch, legally speaking, you could argue that those provisions are redundant because what they seek to do could be achieved by other provisions in the criminal code.
Wolem nyintiko hani wo fango amanlo la soto katu na banko la kruya sartol ni luwalu men be laring ni moyo ku kurum façon luke wo luwal ni wo sartol fonction mari kulunole satara amanke ni loi kutoti tele ni membondi teng.
Yeah, that I will agree with to the extent that the negative effect of the economic crimes decree
mbeso na wala le katu ni ajibe nyimfanka tinya sarto me yalo nditeng ala fanna me yalon ko mu kujen keren nyinneti meye mantoro sabu
is to use it to silence critics of the then administration.
Ya wuli nyina kama kamolu dendi men yalon ko wolle kata moluti menuka doyaro ke kolula menuka te kutinyari ngulti menuka bo sembeti wala karola.
And by pretty much including it as a saved act by the Constitution, you're basically tied. You cannot challenge its constitutionality in view of the fact that it is already sanctioned by the Constitution.
Hanika bi komen abelare nyame ko loi nyin kono ala dero nyin kan loi bu ko nyin kono ite wulino la kam yafo ko iba bantambilla nyaado ka kele ka dun abe loi bu ko nyin kono.
Yes, you know, in law it's very difficult to make conclusions.
Omutonyali katuniye lua lanya dolu jibe akakoleale pour kata koti alfo ko dandula.
Because there is a way out of every situation.
Katu ko kundin lanya keta nyawonya ndi nyama silo bijele isi fintino wakono
Yeah, I will agree with you to an extent, but then it is possible to challenge its provisions for being unconstitutional and being unlawful when the need arises.
Mbesonna ya fanyameng hanfo tukumudoto ka foko kulo menni sarto manta wala ni lua manta barbitun silo bijele mosi tukum balano tukum la dami ning ayatara mfutatama hanfo akobulita.
Well, Mr. Mboja, we would leave this debate for some other day.
Thank you very much,
But you would agree with me that the test of constitutionality is the Constitution itself.
Yeah, also to an extent, not 100%, because if a law is inconsistent with the Constitution, it is null and void to the extent of its inconsistency.
Kadunia jibe ni lua atatake fentime ya lonko amalo dula suruna bankola lua sarti bukuba nyinkono wodo mukuleti me ya lonkasi landi karala.
That is a basic rule of interpretation in constitutional law. That is why I said the test of constitutionality is the Constitution itself. So in order to be able to determine whether a law is inconsistent with the Constitution and therefore unconstitutional, you have to put it against the Constitution. Is that not the case?
That is correct.
But when the law is saved by the Constitution, just like the decrees, it is pretty much. It depends on how it is done, but it looks like it has been incorporated into the Constitution. I haven't looked at the provision to see the actual effect of what they have done. But if it is incorporated into the Constitution, you therefore cannot challenge it anymore. Because it is now part of the Constitution.
Yes, I will agree with you, Council, again, but it's difficult to agree in total. Yeah.
But anyway, let's leave this for another day.
Because a constitutional issue, yes.
Yes.
Constitutional quality.
But for now, we just agree that that law is a draconian law.
Exactly. Yeah, part of it, the latter part of the decree, especially on the issue of bail, is where the unconstitutionality arises.
Wala bari ala fanna do me ya lonko amang akeja uyata wolem alabandula me ya lonko bel ko ba ko mem balanta bel ko la wala fawni sartolu manta.
And like you said, in spite of its good aspects, it was liable or amenable to abuse by the executive.
Ya lauda ni nyala me ya lonko executive volume santron quality wolka lana tambile.
Yeah, I will agree with that. I will say rather that it was designed in purpose to silence critics, because anyone in the system then
mesonna ko tonyala ya dada wala kama andun ya yitel tama be tamari nyina ko mennu ka doyaro ke kukurun ko la men ka bo man sakunda la karola ya wo wato la ya nyina kam ma wotilolu kono pour ka o mariolu dendi.
That's a damning statement, Mr.
Yes.
Boch.
Yes.
Wouldn't you be contented with just the formulation that it was used instead of designed? Because the design and the use may be different. It may have been designed with good faith objectives, with great bona fides, but its application may have been malafides.
Bari iba dadala tumo men na kalondi ase keno akatangani ya kendo le kama bari iba tamandi la tumo men na doli yake ya kanyina kama nyado nyama purka imuna fangala ka dunola doluka.
Yeah, I have a reason for saying so.
Ngadalilo sotole de purka ofo.
The promulgation of the decree
came
at a time that the then government of the APRC was AFPRC was trying to establish itself.
Afindita tumomen na wotumo mansakunda membelori nu wotilolu kono memu AFPRC mansakundati iba katakan wotumo le purka isimulu londi kabambam.
And then there were so many critics
against
the military regime. And it was promulgated at that time when anyone criticizes the system.
Andu ya wuli ya fintindi wo wato le kalondi ko mo womonding ye wo kuolu lanya doya.
You become the victim of the act or the law. Exactly.
Well, that is a belief you have. I beg to differ.
That was my understanding.
And I beg to differ. For I think the Economic Crimes Act was Decree 33.
Decree 33.
And that was passed very early on in view of the AFPRC mantra of transparency, probity, and accountability. You remember that?
Yes. I remember that very well.
And the belief at the time was there was a lot of theft of public resources leading to significant economic losses.
Andung idol lata menon wala ngindi ko wato la fanko sunyaro sia batan wo wato wala ya sabu itol jikita nyina pour kanyi luata ka dundi ka dum mansa kunda be foka naful jamalla.
So it was passed at that time. The objective may have been laudable.
Ya munda ya luwa nyi dundi wo wato la bari hamen ko medin asikeno ay hamen ko kendotin.
But it was seen that it could be used to clobber political enemies.
Bari dol ya jele ko asikeno ya luwa nyi dundi la pour ka politika nyaton ko dol ta ke kele.
Hence the charge against your clients.
Tumala men na ye tumiro do la ifan la kiliano do kam.
Because what would constitute economic losses is quite easy.
Donc fengo me alon ko wala bina sababu la fanko fola ka fo sone ada bakele.
So tell us about the case. The charge was economic crimes.
Sain wo tumiro nyingo case nyina kuma fo nyama tumiro mende wala mfanko tinyati.
Yeah, we have procedures guiding the courts.
Nga tarangol le soto tarambulo lu meni alon ko wolle ka polu sambanya banke kiti bundala.
But the then Secretary General, who was supposed to be the principal witness,
Katu barwo tembo memu Secretary General ti do kulalu kuntonko menyanta kala sede nyatonko ti.
Name?
I believe Sabali, he replaced Dr. Joguba.
Which Sabali?
Momodu Sabali.
Lata like kafaina Momodu Sabali atele saita Dr. Njoguba la palasoto.
I don't want to say he refused to come to court, but he failed to come to court to testify.
Nta fono la deko abalanta le kana kiti bundala. Bari aman silota kana kiti bundala kana sede yaro.
Was he subpoenaed to come?
Kaido ki ay nebang kafme supina pour ay na idango kiti yo.
He should have been a prosecution witness.
Ate nyanta kala kiti ndir sedo letinu.
But I can recall that we, the defense, have requested for his personal attendance.
Bari hakilo bala nyina ko. Ndelu menu be lori ngin tumi moli ye. Ndele nyin kanim puru atena sede yaro la.
As what?
As a principal witness for the prosecution.
Ake sede kebati kitindiro la karola me ya lonko wala be lori nyi mutamolu toyala.
But the ruling went against us.
Of course.
Bari nata polu tamandi nyame
it is the prosecution's case.
Wala mko kitindir bunda nyi wolle la kom.
And he sent someone.
It would have been shocking if the court had ruled in your favor.
Ani ko ya warana ninga atara kiti yo nyi ya kango nyi kuntung altolela dunyoka.
He delegated a witness
To represent
him. And that was the only witness for the prosecution. But the funny part of the defense was the diary that was my client's main exhibit.
Wolem diary ti ka kolu safe buko men kono kuke talu wala montela mola sede bambande nguti.
I still have that diary with me in my office.
Wo diary hanim biya bente bulule na office kono.
Where the accused person recorded in his own handwriting the instructions of the former president.
Gamen ni muta mo fangoye kuma kangolu safe a fango bulo la diary men kono damen me ya lon ko wolle keta kuma kangolu ti menu bata tumo president bulu ya jamme.
As a defense to indicate that he did receive instructions for the arrest and prosecution of the then Justice Wowo.
Andu wala mnyinti we nyine itandiko ya maroli nyine itandiko puru ye mo muta aninka kitindi me ya lon ko tumo wala mkitindi lati kafa me Justice Wowo.
In order to appreciate the import of what you have just said, perhaps give us a brief background into the case. What was the case about, so that we can understand actually
case nyim fon ka dunga kono man ya be fonye abakata nyame pour sa faham case nyim e be quand même sata moleja.
This was a complex case and it's intertwined.
Nyimukitile time ya lonko duladolu ala kolu selta nyoka bari duladolu ala kolu dunta nyoto bake.
Break it down into simple facts That we can understand.
Abonyi nyoro nyala me yalon ko mba faham lale.
Justice Wowo was a judge of the high, in fact, he was a state council. He started as a state council before he was appointed a judge.
Justice Wowo ya damuta tumo na mansakunda la kitindirlale mwoti wo janning iba tombo na kake kititelati jojoti.
And then while serving as a judge, he was elevated and promoted to the Court of Appeal.
Wato men abo kitite bundala utumole natala palaso la faka selendi kasamba kitisa inkambundala.
Within a short period of time.
Wati sutum fangokono de.
Roughly about 6 months.
Kari woro wuche okono.
And then elevated again to the position of the Chief Justice.
Andu inatala palaso sen kang teriandi ka lafa kasamba kake kitindirla kuntioti wala Chief Justice.
But then the sacking of Pa Hari Jammeh and lawyer Lamin Jobate
Bare Pa Hari Jammeh ila bayo atening lawyer Lamin Jobate
was an issue at the time.
Umukuleti wotembo membe loring.
And then from my client's instructions,
Kabontela kiliano la yamaro lukang.
He was instructed to ensure the arrest and prosecution of then Justice Wowo.
Ye nyine fay pro asikuolu tamandi mensa sababu pour ye Justice Wowo muta ka kitindi.
But then Pahari was Solicitor General.
Wotembo Pahari mu Solicitor General leti.
And my learned senior Jobate was Minister of Justice.
Aduna keba meya lonko wolem Lamin Jobate atelo minister ti wotumo mem marta kitol nintilimula.
These were present at the time of the instruction. The time the instruction was given to the Secretary General.
Adunyilu ya sede ale wato mebo ya marolu dila Secretary General fangola.
And then after the instruction was given by the President, which was recorded by my client on his diary,
and had by the Attorney General and the Solicitor General all at the same time.
At the same time.
Attorney General and Solicitor General
The instruction was carried out. Wowo was arrested. He was charged. I can't recall the charge. But then there was a change in circumstances. And the then President, Yaya Jammeh, reneged on his instructions and said he did not give the instruction. Because there was a diplomatic issue which arose as a result of the fact that Justice Wowo is an American citizen.
Dia moment nata wuli okola wole mnyintiko kwolu nyil nata koleabulu katu nata nyina jako Justice Wowo atemu America banku dingoleti
and had an American passport.
Adum America passport ole babulo kono.
He had dual nationality.
Dual nationality.
Yes. Banku di fula dingole mwati.
And then when the American embassy got involved into the case,
bring America la embassy ye dabula kito nyinkono
and raise issues about the legality of his arrest and his trial.
Inata kwolu wulindi menno tilinta ala mutoni ngala kito la tilimbali ala.
And then there was a change of instructions.
Yamarol nata falin kote ke utumo.
That he never gave the instructions.
Ate meye yamarolu dinum sedolu nyala nata lokate mawo yamarol.
That led to the arrest of both Njogu and Pahari and Jobate.
Wole natake sababoti ye Njogu ni Pahari muta ani Lamin Jobate.
And that warranted.
But that could have only given rise to a charge of
abuse of office.
Abuse of office and false information.
Abuse of office was a charge.
Osimen wulindino wole mkafoko ye tinyaro lekela wala ye tilimbali ya lekela office okono.
Okay. Whilst the trial was ongoing on the abuse of office,
kito betama kantumo menna wo tumiro la karola kafo ye tilimbali ya leke office okono.
Let me ask this question. How could have Sabali been a witness? Or his representative? How could either of them have been witness to this case.
Sabali was then the, I don't want to say Deputy Secretary General, but he was a direct assistant to the then Secretary General Njoguba.
Sabali manke Secretary General ti wotumo de baribitum atele simbe Secretary General kan wotumo memu Dr. Njogubati.
And he was like an assistant to Njogu because he said he was present then when the instruction was given.
Andong atele moti mem sinan ko be Njoguba kan kat wotumo ka fana mbijele wo kumolu be fulatu momen.
I think this was a case where the witnesses would be those who personally perceived what happened. So I wonder how such can be delegated to somebody else.
You're laughing.
That was the very reason why we were asking for his appearance, personal appearance.
But
that was not the case. And instead of coming to court, he wrote his statement, gave it to the witness, tendered as an exhibit, form the basis of his evidence.
But that is unlawful.
That was the order of the day. That statement was wrongfully admitted.
That is clearly a case of hearsay.
And the diary, which was the most relevant document in the trial, was
contemporaneous record.
Because it was not rejected, it was returned.
Diary me ya lonko wale nyanta kela sede bambandingo tikumolu safeta memkono ya manka ko balanta la de bari ya murundile.
I tendered the diary as an exhibit.
Ntenga o diary sambale ka ke sede kangote.
It was neither admitted nor rejected.
Bidung imanna songatala bari imam balanga la fana.
But there is no such position as evidence in limbo. You can mark it for identification, but and use it subsequently. And even marked for identification is not used in Gambian practice. It's used in the international tribunals. But there is no repository for evidence in limbo.
Lu osede yar sifa atana lu alfango kon hanna ro daire ni hanni yar nyan isa tanu ni ba kala no suter langolti but hanna ro suter lang fan dolla lu al tamandri nyaro aten mamira beje ni banku ni benka kiti bundal de wala kay munafal ka ni festival ta ka ke suter lang de ka fme ID bari dolla jang ateje.
The narration is creating a scene
that
will be unfold as we go along. Because even though the then Justice Care was we were very close. But I will simply say there was a travesty of justice in the case. Yeah, because after the rejection of the diary, it was neither admitted nor rejected.
With all due respect, Mr. Mboj, what you've just said is a contradiction in terms. Yeah, after the rejection of the diary, it was neither admitted nor rejected. Is a contradiction in terms.
After the return of the diary, thank you. After the return of the diary, yes. And
wouldn't that amount to constructive rejection of the evidence, if you will?
Oh, kitio kono foto kela nyindi ko afoko wrong. Sede and roning ibalanta la ko tilimbali akono mo safo.
No. I say constructive rejection of it. Can't it be interpreted to mean that your application to admit the diary was rejected, considering that the evidence was not allowed in?
Well, that
was, yes, I will say yes, because that's a constructive rejection of the diary, but I think it was intended also on purpose.
Mba fola le ko ha bari ila balango o balang lo nya pour ka diary dundi mba fola ko ya kemen kama e fansun dalilo le soto kama.
Did you file an interlocutory appeal on that issue, if that is appealable? Because I think that was the heart of the case.
Inatna wasida dundi le bang government interlocutory appeal pour ka ko nyin ka sengan jube.
There's no time then for interlocutory appeals.
Wati man soto pour sign kandiro ulondo.
Before you will even get your records before the appeal court, the case would have been decided.
Kado hani janning itebe la ku tembendiringulu ila ku parendiringulu futandi la kiti sign kambundala ubata leteli ya kito kundu.
I asked this question just mainly for the purposes of our recommendation.
Jalilo me asabu ngai nyinin karo nyinin ka wala muinte dalilo me bagola mturna ya maro nyimbe mendila nyala bawnyi.
Aren't interlocutory appeals given priority such that they could easily be disposed of and cases continue?
Fo nyin sifa nyin dan receiver nyin fo manyana sudero dilatela santo jannibe kuol fenkela folo kundula folo nyin dan receiver nyin pour leta dum akko nyin kono ka korosi folo ay senea.
This is a criminal proceeding. Interlocutory appeals are not a ground for a stay of proceedings in the main trial. And even if we had filed an interlocutory appeal, it will not be heard before we determine the main trial. Because I will add here that we know as a team that we are just defending our clients. Because it is a legal requirement. But the result was obvious. There will be a conviction.
So you just went through the motions?
Yeah, we were just going through the trial, but I know for sure the result will be an obvious conviction. And that was what happened.
Did you at any point in time harbored any expectations that you could secure an acquittal?
We were on the verge of success, getting an acquittal. Because the evidence of the prosecution was too weak. And the evidence of the defense was overwhelming. But the trial judge, who was Justice Nkia, I think news got round that he was going to acquit and discharge them. And
on judgment day, you were very hopeful.
I was hopeful 100% that we were going to get an acquittal.
And you went to court with so much hope and euphoria.
Yeah, exactly what happened.
So, and tell us how things unfolded.
Another interesting scenario arose on the judgment day.
Tell us about it.
Judgment was scheduled for 10 a.m. We were all in court as expected. The judge did not come to court
Bitun kitindirla ni manna kiti
till
bunda.
1:30.
For talang kilin nintala.
Everybody was anxious,
Mo bebe deunding.
nervous,
Mo
and
bebe
worried.
sularing. Mo be akata mo be deun koti.
Where was he?
abenu mindole ata kiti tela
The judge was in his chambers.
Abe ate kitindirla bala ofiso kono wotumo.
How did you know that?
ite ye wolo nyaadi le
Well, we were all there, right at in fact, we were going up and down between the court and the chambers, asking the clerks about the time. It's time for judgment, but the answer is, my lord is in chambers.
Bari mbele bijenu mbetani nala mbeselenin jiwala nkakila ko lu nyininka wato la ko kitite wato sitale bari ka jabiro men dinna walamde kitindirla nyimbala ofiso kono.
Was his lordship in his chambers alone?
o ate nyin kiti tela nyin ada mala bala nu office kono ba
Well, the rumor,
nga moyla moy kumo memmoy
which I cannot confirm independently because I did not see it,
me ya lon ko nta tonya ya ndino landam man kunkilo katu mfango nyamaje
was that there were plainclothes officers in his chambers.
ko molle bala ofiso kono wotumo men ya lon ko ibuka uniform dung bari service lalle muyti.
Which service did they belong to?
boran na tanko bunda fanna jumal to
Well, we believe that it was the then NIA,
Ndelata men na wala mnyinti wotumo wo NIA ulu men be caring.
because the NIA are following our proceedings on a daily basis.
Katu NIA ulu be bularin to lanyin kito normally luolunding.
But at 1:30, when the judge came to court,
Bari talankilin nin tala bilin kitindirla faunata kiti bundala.
he came with a judgment that resulted to a conviction.
Anin kiti teo men nata nyola wole mnyimolu puruke sorong.
But the way he walked into the court
Bari atama to duntanang kiti bungo kono nyameng.
and delivered a marathon judgment,
Anata kumajang sata je men kita kiti teo kenyati.
walked out of the court back to his office,
Anata finti kiti bunda kono nyameng katala ofisoto.
created a lot of doubts
We hakili nyami jamale sabu.
about his personal well-being.
Mentilintate fango kungo fango taranyala.
Because what we are made to understand was that these officers in his chambers had to pin him down to reverse his previous judgment.
Katuntelinata memoy. Wala mnyinti ko nying officialu menu ma uniform dung menu bala office okono ya sindile force okang puro atanyanta kito tela nu nyaming ka wo faling ka kudo kije me yalon ko men kiti atela kiti tinya pareta men nanung men ni wote kilindi.
And I can believe this because I can see it written all over his face.
Adum mbela lawla katu hanni ate fango nyada jube ibalon na anyada leto.
And the way and manner he came in and delivered his judgment and out of the court.
Aning anata dum kiti bungo kono nyaming ananya. Aning ay kumo nyim banke nyaming. Aning biraye bandi anata finti of kiti bunda kono nyaming. Wolbe mutaman serol.
So, you believe there was judicial interference?
ilata nyinna ko
Interference in the judiciary.
ilata nyinna ko dabulo keta kiti te ila kiti o nyinna karola
That was obvious.
Wumukuleti men seneyata.
What was the basis of the conviction?
sorondiro nyin ya landi nyaadi bulu jumal kam
Was it that letter of, supposed letter by Sabali or supposed statement by Sabali?
fo ya lani nyame na wala nyindi ko sabali
Ayo kumakango men safe kakina.
kinang fo kiti o suita wala ba
Yeah, that was the only evidence of the prosecution. So obviously that is the only basis of the judgment.
Wodorinem kaito tiko kiti ndirilalu ye men soto ibulo kono. Boto ndele aje ko amonta itelela kiti teo sembe ndiwo kaito lela.
Did you appeal?
alnat na saf daniro kala banka safiro ke pour ka kiti o nyin kamburun kamba ba ko
No, I did not file an appeal because my client instructed for his own peace and safety and tranquility to let the matter rest.
Man kiti sain kankaning. Katu ntefang la kiliano. Wole natanyi ya maro diko. Nga kuoti jate fang la tanko. Anala fansoto. Anala kairo kang. pour nga ko ñin tuji.
But another interesting situation arose before the judgment.
Atu ba kudo fanan nata wuli jannin kitite obekela mem fanan musula kudoti.
When obviously even the gallery who attend the court knows that these people will end up with an acquittal.
Hanim molu menu nata jibe roni lamoy rola wala silulato mo jama bi je lata nyila ko e be nyilu bulala le.
And while that trial is going on,
andu wo kito be takantu momeng
to ensure that he is not discharged and acquitted and freed,
kaje ko e kana nyilu bulaka yamfe yeta.
Another charge was leveled against Dr. Ba again.
Ina ata tumir dole la Dr. Ba kan kotake.
And another abuse of office.
Andu me yalon ko fanamu kuleti me yalon ko kay tilimbali yala kala.
And this time that was tried by the Banjul Magistrates Court.
Andu silo Banjul Magistrate kiti bundala yo kitota.
Once this was completed,
bring dom banta high court dron.
we continued with the one in the Magistrates Court.
Ntententa kawodo tamandi member Magistrates Court.
Wouldn't judicial economy have demanded that they consolidate the cases?
Oh, kiti bunda ni ngol man sembo ni sota pour ka en case flow ni beta ke kafundi ni wanka killing.
The High Court has obvious jurisdiction to hear any matter.
Na kiti bunda ba ni high court wali silo soto le pour ka ko kundi lammo ni kito lem.
But the reason for the second charge
Bar dalilo me nyin tumir flanja ko sababu
was the anticipation that this man may be acquitted.
wolem nyinti jiko bala nun ko nyin asekeno yabula.
That warranted a second charge against him.
Wole tumir flanja nyin nana sababu.
And that went up to ending when it's time for judgment.
Andu wo tata le hanfo ko bandula bring kititeo wato sita.
When the state filed a nollie.
Bring mansakunda la karo wole kudundi ko
Nollie prosecute that they are no longer interested in prosecuting.
ko mang sola soto kota ke pour ka nyin kito tama.
But that was after serving his 2 years sentence already.
Bari wo yatara ayala sanji fulo nyin la serondiro ayo la fuka pare.
Interesting.
Yes.
But your belief is
Telata menna.
these are trumped-up charges.
Ni mutu mir le me yalon ko tumiri tili men silo manta.
For what objective?
Dalil kam.
Yeah, the primary objective of Booth
Dalila follow membe lari nyin kufulo be koma.
to ensure that what the former president said was right.
Afoko membe president yala lungo tumo na kuma kumandi mfo
He
wala
did
mutonya.
not give instructions for the arrest and prosecution of Justice Wowo.
Wala mnyinde ko kafoko atamanyi ya marodi pour ye justice wo muta aninka kitini.
Are you saying, Mr. Mboj, that he lied, and in order to cover up for that lie, these people had to go to jail? Attorney General, Solicitor General, and Secretary General of the government?
Exactly.
Be men foka wala minti ko nundo president men benu jango to ay kuma soto balol fa fan yale fo ka tun ka abe o keno la nya wala nyindi ka be maboro nyi abe o timmandino la fan ka nya wala nyindi kanyum molta ke soron man sakunda la ministre men marre luwal ni kitindire kunya la benu nje attorney secretary general benu nje
do ku be kuntonko
do kulal be la nyaron ko fana be no maberi nje ñun be tara je ay
Yes.
soron.
Exactly what happened, because the issue of Justice Wowo when the American embassy got involved changed the whole scenario.
wala keta katu bring America la embassy o ya dabula justice wo wala koto dron
And they were
wala
coming
nata
to
ko
court.
be falling andu
They were-
kanale fon kiti bundala
They were coming to court on every sitting.
si wo si nin kito be kala wolu kanale kiti bundala.
But that was a very expensive cover-up.
Bari wo mu mabori ser limbalti.
Well, it led to the trial of and conviction of all three top government officials.
Andu wala nata ke daliloti
In
de
fact, the most senior civil servant.
wala nata ke daliloti ye nyimmo sabo be soron adu niaji be nyilu mu banko kan alifa balleti nun katu ila palaso lu men be bulu amanke dindim palasiti katu memmarata banko do kula bela banko do kula bela kunton ko dabe wala kon.
But all these things happened in a climate wherein the executive had little tolerance for defense lawyers who were basically a nuisance to them, or defense lawyers who were pretty much a stumbling block for the government securing conviction in cases in which they were interested in.
Imbe kera jamane la me ya lon ko akera jamane me alon akera jamane ko lango kono me alon ko be kany mol be ta ki kitindi executive même santon kolti mam bunya ni hormo soto ni loyal me alon ko le tara lori ni molie tumi molie hanin kabi kane ke dabula kitiol ni kono loyal ni fana hani ko ku fenke ibukana hormoni bunya tamande ko ni kono.
Perhaps let's not cast it in institutional terms. Let's just call the personalities. Yaya Jammeh.
Nkana samba ni ndoku bunda la sila nga samba mo kunkilina la kula wala Yaya Jammeh
wanted convictions in cases in which he was interested in.
Alafita ka pour ka sorondiro e soto pour mola melango tumi mola andu atay sulo soto case nyindole.
And had little tolerance for defense counsel who were making things difficult.
Andu loyal mi melango wala tara lori go mole tumi mole ni abuka son woli melango wala bi loro tumi mole abuka son ife wala loro tumi mole.
Yes, I think you are giving a little bit of credence to his reactions. It's a zero tolerance, not little tolerance.
Namira munta telaw balanda ibe nyinyandi kande ka fo little wala demanding ay songo demanding ka man so mume kele wala zero tolerance abuka pare ka wala kumo fo ka wala ko fo ta fereng.
He's referring to defense lawyers. I'm saying he had zero tolerance for lawyers.
Awala lawyer lu meni alon ko e ka lo muta molie ate mam pare wala ko fo ta la nyaaw nyandi nyama.
I didn't realize it was that bad, but thanks for that correction.
Can
you give us examples of some of the events that took place which suggest that he had zero tolerance for lawyers?
Ni sim kane sivala soro ni loyal meni alon ko lekatara le lore ni tumir moli ko amang hani song abuka song hani fa woli loyal ya pour ila ko ila do ku ñaar.
Well, my colleagues who came before me mentioned some examples.
Yes,
but I was part of the defense team in the Baba Job trial.
And
we all agreed that the shooting of the then and our learned senior counsel Usman Silla nkafunyo memun na kebati wotumo loya ya la karola ya bung menketa Usman Silla te wobundiro. I was as a result of his defense of Baba Job. Wala keta nyinkama ko aketa moliti mello ta Baba Job ye. And the case of my Fati also. And my Fati fanana ko fanam.
What happened to Mr. Fati?
Mr. Fati.
We were all part of the same team. After Mr. Silla's case and he was evacuated, the next in terms, not seniority because I senior him, but the next in charge of the case, Mr. Silla kola mo du fulanja mo membe maralin kito la manke ko atele bente nyato keba yala bari kito nyi na karola ate be mo le kono menu martala Mr. Maifati. Wale Mr. Maifati. And then I am made to understand that his accident was not a coincidence but designed. Ala accident moto accident o men soto amanke ko kule meya lonko abentafe bari fere sitiri ngolom ye men fero sitia kama pruka dabo ndikolo kono to get rid of him in the defense as well. And I got confirmation of this fact. The team that conducted the accident, Mr. Fati. You mean
the team that staged the accident?
That managed the accident, personally made these confessions. Myself, whilst I was in prison.
Who's that?
I can't recall the names.
Mr. Mboj, we can give you a piece of paper to write down the name.
No, I cannot recall the names. But I think my
Is that a way out of the situation? You
No.
could still write the name down, Mr. Mboj.
No, it's not one. It's a team.
It's a team, which makes it easier for you. If you can't remember one, you could remember the other.
My learned friend who came before me, Nene Cham, represented them in the court for their mandamos. Compelled their appearance before the court, and they were discharged unconditionally. It was a team of 7 members.
Junglers, NIA personnel, or what?
They don't belong to the junglers. This is another group that is conducting massacres, accidents, carrying out personal attacks against critics in any way. As long as they are given instructions, they carry it out.
Menu be mo fala nun kamolu boyinkan kamolu tajireya atutal drong kangole bulunie kango di tolla drong ye kuma wo kuma fay toliye amunta tel ni wala kawli kata bara wala.
Do you recall the name of the group?
Kafo nyinga to ya hakilo ya mutalaba.
I know they are within the army.
Na lon ko be sojar bundale kono.
But they were moved from the main from the barracks
to
the state house.
Ye be samba state house.
So they were among the state guards.
Itata state guard man sa kantarla le kono.
And what kind of uniforms did they wear?
They don't wear uniform.
Yelo buka uniform dung.
They don't wear uniforms.
Buka uniform dunde.
And I can tell you how they even. Sorry?
Who was the leader of the group?
No, this is what I'm saying. I can't recall the names because I wrote even their stories down on a piece of paper. I lost papers, but I can remember the stories.
I'll give you a list of names and tell me whether any of them rings a bell.
Yeah, isina fonye ko fo nyimol be nyinu tol mem volé fo mobe sorole kono la ba melan ko abulade sondo mo kon.
Musa Jame.
No.
Tumbul Tamba.
No, I know all those ones. Not
Sana Manjang.
No.
Nuha Baji.
No.
Fansu Nyabali.
Fansu. The name sounds familiar. That Fansu. I think Fansu was one of them. I think. I can recall that name. Because they were detained in mile 2. I found them there. And they were coming individually to come and tell me their own story.
They were junglers.
All right. I didn't know they were junglers, but I know they had jeeps.
By jeeps, you mean 4x4?
Military jeeps. And they have taxis. They have vans. They have trucks. And these were the vehicles that were used to coordinate the accident of Mr. Fati.
But this method of eliminating enemies by way of staged accidents or vehicle tampering was not limited to just Mr. Fati.
Yeah, I agree with that.
Could you give us other examples where you believe these methods were used?
I had the personal experience myself.
Tell us about them.
Well, the first one was I believe, an NIA officer.
Follow, lata la ko, NIA do kula.
Name?
So,
Well, at the time, I didn't know the name.
Akobe kala tumo na mama ri tolonde.
But through my own investigations,
But
I later realized it was Mr. Lamin Bojang.
Na kisikisiro kono kuolu kola nata atara otumo le ko ka fayne Lamin Bojang.
Residing where?
Jambanjeli.
Amaribe sirin Jambanjeli.
The first attempt was even at my house.
Kata follow men ayake o mu mfango la bungo fango kono letide mbelna bungo kono.
Which year was that?
Sanjuma.
In Brikama, this was in 2006.
Mu Brikama leti 2006 sango kono.
During the treason trial.
Wato men banko jamfa jawo kitolu be
Of
keri.
which case?
Yes, Juma.
Bunja Dabo and Co, Farin Sanyang and Wasa Kamara and others.
Wala Bunja Dabo, Farin Sanyang, Wasa Kamara, nin kotangol la kito be kekantu moment.
Where were the proceedings holding?
Kitio nyinga kenu mindole.
At the Yundum Barracks. Yes, Yundum Barracks.
Sa kito li ke yundum sojar kordal to.
Proceed. What happened?
Neketa.
I already started my Maghrib prayers
Ngultalembe ngasalo damuta
when my sister ran to call my attention.
mbar musoni mboro nata kankumandi.
There was somebody in my car.
Mo be nango to kono.
Where was the vehicle parked?
Moto nyimbe lori num mindole.
Inside your premises or outside?
Korda kono bam fu korda e bantala.
The vehicle was inside my compound.
Moto be lori na korda fangole kono otumo.
Was it a fenced property?
Korda ni ya sansan fensol la ba.
The property is fully fenced with a gate.
Korda be sansan din fa pareta hanufo bunda be kordala.
But I cut my prayers.
Nganna salo kuntu.
Whilst coming out,
Be finti kan tumo men na kana banta.
I had the bang of the door.
Ngamoto bunda busakango moy.
When I came out to the gate,
Brinna ta bundala korda bundala.
I saw this vehicle zooming off with top speed.
Nanyi moto haynanga nimbori babita kang.
Can you describe the vehicle?
Moto nying la kalon nyi sa fo no mole ba moto nyaadi lem.
It's a four-wheel.
Nyemu moto ultime ya lonko asinano be ka choki ka fole 4-wheel.
It's all black
Bebe finding.
with tinted glasses
Awero lu fango bebe dibiring.
and without a number plate.
Alum nombate moto nyinna.
What did you learn from that?
Itina na mune karan wo baroto o kuoto.
Well, at the moment, I immediately sensed that this is a plan execution of an evil.
Hakilo eme muta otemboto ko fere sitiri ngolo nyenti me ya lonko amario ya wuli menkama wala mkama siboke.
By who?
Kabo juma kan.
Well, I suspected then that it was the NIA.
Nsobita otembo ko NIA wole.
I don't know the person.
Katu mario long.
Because I knew then that they drive those sort of cars.
Katu otembo ngalo ne ko iteleka o moto fasongo luborindi.
But then my mind just tells me to let it go because it's not safe to chase somebody who is trying to put you in trouble. You are chasing trouble, so I let it go.
Bari hakilo nata nyindi nako. Nyintutu laje ayeta. Katu momel lafta nyoma siba jao kelete marila. Purka o bay. Ima kalangolong amankwe.
But that was not the end of it, was it?
Pero ko nyi dandula manke woto defo.
No, certainly not.
Hani amanda woto de.
Proceed.
The second time,
Sinya fulanjango.
another plan execution like that
Ye fere do be fanam city membe ko wo.
was during my trial
Wala mum nakito be kekantu momeng.
at the Banyan Magistrates Court.
Banyuno kiti bunda bala magistrate court.
I parked my car outside the court,
Ganna moto londi kiti bunda e banta.
went to the court,
Data kiti bundala.
and came back.
Muruta nang.
At the end of the case,
Ring kito nyimbanta.
and I was going home with my family in the car.
Ninna dimbaya lu bebe moto kono mbese ikang.
But then my tire was shaking,
Na moto singo be jara jara kang.
and I could feel from the steering that there is something wrong with the vehicle.
Hani baro membe mbulo kono ayaitandina ko kule keta motola.
Then I could not stop inside Banjul to check.
Mallo no banyunu sate okono purka jube.
So I drive until I got out of Banjul
Ngamoto borindi wonyale fom fintita banyunu.
and stopped to check my car.
Lota purka na moto jube.
My tires, bolts were all loose.
Na moto singula bulongo lu yewlu be yom fandile wotumo.
And 2 have dropped already, only 3 were remaining.
Fulo be jolon telefang amunta sabole tuta dinkirato.
For each of the tires, for each of the wheels, or just one?
Moto singol be bam before moto jet sing.
Only the driver's side.
Drive for la karo dorong.
And then I called my family in the car to come and see as witnesses.
Nganna dimbaya lu kumandi menu bemfe moto kono puri fanaliye finti yenaje keste doti.
And that rang a bell in my mind
That
the NIAs are following my case on a daily basis. And this could be another trap to get me involved in an accident.
And there would be a third time.
Certainly, yes. Certainly, yes.
Tell us about that.
This was also during the treason trial. It was time for Tobaske. And I was going home to the village. And I had my whole family in the car. But then the vehicle was loaded, fully loaded with I can't even more than 11 people. All the seats were occupied. I parked even the boys at the boot. But then, due to the load, I could sense from my steering when I started driving that there is a problem with my car. I stopped and checked the tires, but none of them was shaking. It was dark. It was after Maghrib prayers. I didn't notice that my bolts have been loosened again. And this time it was the rear tires. So I was driving again, and still I sensed that the car was not driving normally. Because it was shaking at the back.
Was it overload? I mean, for a 7-passenger vehicle to carry 11 people.
It's not only the people. I loaded a lot of stuff in the vehicle, and even the roof of the vehicle was loaded. But then I, just out of caution, drive safely and carefully. But when I finished Kalaji, then the tar road stopped at Kalaji.
But wotumo mano danta Kalaji le. Bitum brintata hanfo no mano bang Kalaji.
And then I entered Kiang.
Ndunta Kiang.
Then there is gravel and the road was bad.
Andu wotumo bere silo sila nseleta wale kang adun silo nyimambete.
And I was driving, I just had my car boom on the ground.
Mbe moto burindi kan tenata mune moy na moto boy ta dumala akumata boom.
When I got down,
Rinjita.
I couldn't find my tires.
You couldn't find your wheels.
My wheels. And it was late and dark. And it was raining at the same time. But I had no choice.
bari fere do tembulu.
Well, I would understand if the tires had busted. Then maybe we could say it's weight.
Yes.
But for the wheels to wheel away.
Away from the vehicle.
Moto singulu buta moto fango balale fereng.
And then the
How many wheels?
the two back tires went off.
Moto koma simfulo bele buta moto bala.
Because the first went this way and the second went the other way.
Kadu fulo nyin tata be ma fango melna silo bula. Flanjaw nyin fanam be karo melna fanan tata.
You believe your car was fingered?
Yeah, that was for sure, for definite. And I will tell you again why. I came to realize that this officer who was, to me, assigned and personally monitoring me,
Nata korosiko. Yanyi mari mentombo mpura bulantela kolu noma kankorosi kana kalango jibe.
he passes through my gate at Maghrib time.
Akatambi na korda dala fitiri wati fitiro sita.
When it is dark.
Nindi bodunta.
And this time around,
Andunyi silo.
I parked my car outside.
Nana moto lundi banta.
After loading it,
Biringa sarse foka
I went to pray Maghrib
Ndata fitiri salola.
and then came out to start my journey to the village.
Fintita na mpuruka tama silo damota katana bulu sate oto.
So again, it occurred to me
that
it could be the same person who is just trying to make me crash and have an accident.
Member katakan dorong purun tenga na moto e boy na accident jawo soto.
That is it.
And it seemed that during that time you were basically prone to accidents.
Mununda fere ko wato la ita molde me yalon ko accident ode kule me yalon ko katu kelela.
Yeah, not from natural causes anyway.
Abuka ke koti ka foko alandaro lem.
Accidents are never caused by natural causes. Vehicle accidents are not caused by natural causes. They are caused by people. What happened? What happened in the first instance?
Yeah, several. After those 3 attempts, this time it was a taxi. At my gate again. At night again. And at odd hour. Then everyone was in bed.
At around what time?
This was between 11 to 12.
And what happened?
I went out for a mission. And I came back between 11:30 to 12. And when I approached my gate, and the full lights was on my gate, this taxi was parked at my gate. There was a driver inside. And there was somebody between the vehicle and my gate. Well, this time it was digging. And I don't know what it was for. So when I approached, the one digging got into the vehicle and drove off, again with speed. So when I got to the gate, obviously I saw the marks.
Or the hole?
The hole already, because he started digging. But
did you see anything in the hole?
No, he could not complete the mission. So I just went in, I stood and looked at the vehicle. I could see it zooming with speed. And then I went home and I could not wake anyone because everyone was in bed.
How did you feel with all these incidents? What impact did they have on you?
Yeah, just making you more cautious. Because it's not out of fear. Because if you have faith, it's difficult to get you harmed.
But faith does not shield you from fear, does it?
It's fear that will expose you to the harm. When you have faith in God, you don't fear anybody. You don't fear anything.
Were you apprehensive of the situation? Were you worried for your safety and security?
Yeah, that is obvious. I was worried. I was worried, but not afraid.
And more serious things were to happen later.
That
That's
is
about it.
This time it was around 2016.
2016
Was the end of the Denya Jame regime. And in particular, in December 2016.
December 2016.
I got news myself that some lawyers were being listed for possible arrest to ensure that there is no one available to swear in the incoming president. I heard of SM Tambidu, LS Kamara, and myself. But then I had already moved from Brikama at this time. Canifing.
But before then, let's talk about your accident.
Yes, that's another very, very interesting accident. Because it's difficult, really difficult, because this time it was a real attempt on my life. This was a truck, 10-wheel truck. And up to date, I don't know the driver, I don't know the owner, I've not seen them, none of them has been arrested, neither prosecuted. So the accident just went. This accident occurred in August 2016 whilst I was going to work. And I don't know exactly what happened because I was trying to make a call. I just had.
Who was driving?
I had a driver then. I just had a bang on my car. And all I can hear from people around is, he's dead, he's dead. And the news went round that I was dead in an accident. But then God saved my life. Because I would have been dead.
Kato aketa nyameng asekeno le ngafaje.
If not for only God's will and design.
Na manke Allah Ta'ala la makoiro ning ala tankandiro kanti.
Because the truck would have climbed over my vehicle.
Kato moto nyingo moto ba asiseleno le nun na moto kang.
And smashed everyone inside.
Adu momondi me moto kona babe nun kundila le der.
How many people were in the vehicle?
I was with my wife and all my kids.
Ninna muso ninna dindingulu bele be moto kono.
I hope this time not 11 people in the car.
No, not this time, because then I was going with my brothers as well.
Manke o silote kato nyin silo ninna nyin silo nindo ko wala nkoto nyol lebe silo kang fana.
How serious was this accident?
This could have resulted to the wiping out of not myself but my family as well.
Nying na ketal nung itelang nganiok be momenti nung ate dan nante dam manna sayala de tombin tek ninna dimbalu bebe tulale.
How many people?
We were 5.
Ndelu molulu.
How serious was the accident?
This truck was driving at a speed of not less than 80 kilometers.
Nyim moto nimboro membita kan niya sumang atambita kilometer tansa yolale minute wo minute.
And my driver was also rushing to catch up with the 9 o'clock case I had.
Aduna driver fanambe hawjari wotu mo puru nse futa wairi wotu mo talang kononto kito bembulunu nyanta menkela.
Now, due to a sudden break in front of him,
yo bari lo sangarale nata ke atenyato.
He swerved on the left.
Atenata jenke mara karola.
I was sitting on the passenger side.
Ndebe siring pasaso sidulal to drive bala.
And in a flash of a second,
adum nyakati ni nyayelo kono.
This truck was over my head.
Nyimoto bente kunto santo.
The noise was so much that it's like a bomb.
Makango wartale ko ni bomo le fetenta.
And all you could hear was that he's dead, he's dead. But the tire of the truck climbed over the tire of my vehicle. And that's why the truck could not climb over me. But due to the speed of the truck, it had to drag my vehicle up to almost 10 meters from the scene. Dragging, pushing my car like that up to a fence. And that's where the driver could stop his truck. But I could see the bumper of the truck over my head.
Bari moto nying ala bompa wolem nyinte ala kubero membe komala no jeng kuntole.
That is how serious the accident was.
Nying accident go jawyata tenne.
Were you conscious throughout?
Oh, waro be ibe fambulle ba.
Yeah, I was conscious.
Manketu mbenyala mbemfambu.
My son was on my lap.
Ndimma be siring wutol le kan.
His head smashed on the dashboard.
He got
three fractures on the head. 3 scars. I myself, I didn't realize that I got a fracture until I wanted to get out of the vehicle. When I realized that I had a fracture. But then those who came to the scene to help me out not open the doors because they were all smashed. I had to improvise to get myself out of the vehicle.
How could you survive that impact? What isolated you from the impact of the car, from the impact of the hit?
Of the truck.
Did your vehicle have airbags?
No, there was no airbag in the car. It's,
Were you wearing
moto
seat
nyim man fonyo boto soto menka molu tankandi
I was wearing my seat belt.
bari na belto be mbala moto
That
la
saved
siram
me, and
belto
that's why my son went over and hit the dashboard.
wala ente kanandi bari wala yakendi ndingu membe nguto kan ate munta ate nyof fighta nyato akumo senta moto wero la nyato wero.
Two things to learn from that.
ufula be wala karana akor
Wear your seat belt.
ila belto city
Don't hold a kid. Don't place a kid on your lap sitting in the front of a car.
kana dindingo ta ya sika ni be moto siri muto nyato ay si wuto kan muto nyato.
Mr. Chair, we take the first break and we will return later.
Thank you, Council, and thank you, Mr. Mboji. You will come back in 30 minutes. 12:30. Thank you very much. Meeting is adjourned. Fine. Council, if you're ready to continue, you may please proceed.
Welcome back, Mr. Mboj.
Mr. Mboj, bismillah, korange.
Thank you, Councillor.
Mr. Mboj, we have covered the several events that took place in your life during those days.
Fanna jamal del ma men yalon ko wollel late kan o jamano la ila balwo kono.
Which you believed were not mere accidents.
Lata men nako men yalon ko wol manke accident 15 wol men yalon ko ala ndaro lam.
But were designs to eliminate you.
Bare ferel men yalon ko ye siti kamal rom pour ke kala fili.
Correct? That's your position.
That is my belief, yes.
But as a legal practitioner, you would appreciate that the evidence in support of your claim is not in fact conclusive.
Well, it's purely circumstantial, yes.
And circumstantial evidence, for it to be the basis of a positive finding, it has to lead conclusively or compellingly to one conclusion.
Exactly so.
And in this case, it is not so.
Well, I have not yet given the conclusion.
Fair enough. But with everything you've narrated so far, it just triggers suspicions.
Yeah, I agree.
So could you proceed with your testimony? Perhaps maybe we would reach to the conclusion where one would have to make a final assessment.
So in
August 2016, you had this accident.
August 2016,
That is correct.
Proceed, please.
Yes, after escaping from that accident, I moved from my house and I moved to Canifing Estate.
Was that a plan or a precautionary safety measure? What I mean by a plan is, was that part of your plans before this accident, or was it done as a result in order to protect yourself?
Yes, the movement was a precautionary measure. And also because of my inability to drive, I get my children closer to their schools where they don't have to pay transport to go to school.
Was it more a convenience measure or was it a safety and security measure?
It
was both.
Why a safety measure? You've explained the why the safety measure. You've already explained the convenience aspect of it.
Mune ya sabu iko aketa kule to me yalan ko yake kule ka puru tankandiro kan ye so ne andiro ni na kumonyi fole.
Well, I realized from the accident
Nata jele ko kabrin accident nyin keta foka pare.
and related to the facts that I already have from the junglers whilst I was in prison.
Andu fana nata na choki nyolo ke ko la mi alon ko wolle kata anin jongula liye kuma kan min fonya wato me ambe kasoto.
Tell us precisely what the junglers told you.
Silang afanya kumala sutun kono drong jongula liye mune foye.
Yes, I can't recollect the name of the particular individuals because all of them come one after the other.
Hakilo fonga mombula de nyimmo fonga de me nyim fonya kato mim keta no wala nyindi ibe kanale killing.
Does the name Bailo ring a bell?
Niyamo Bailo isondo mokono fo be fen mole to mutale yemol mol tol mealan ko mete isondo mokono ba.
Bailo is one of them.
Bailo dabe kono.
I raised the name because you raised Nene Cham.
Yes.
As having been their lawyer.
Niya je ngayin to fo wala nyindi ko yet Nene Cham tole fo jang anu Nene Cham molde mealan ko anana kite nyulla loyati le.
And yesterday she talked about them.
Andun kunung adiamta wala ko wala janne.
And we have correspondence suggesting that she was their lawyer. That's why I suggested that name.
Exactly.
Choki nyolo soto kuma kanjo wala nyinde ngayi miralo di ko asiki no atela on anana kite le loyati le.
Bailo has confessed publicly that he was a jungler.
Bailo waya sene ande kene bato ko atana kite jongula tele.
Yes, he is one of them. And I can recall that name very well.
Adabe kono la andun hakilo bla to mutale kendeke.
What did he tell? What did they tell you?
Ye mune foye ite.
Now, if they have instructions to assassinate anyone,
Say na tarako ye yama rosoto wala kuma kango puru momi yalan ko nyenta ka fale.
they use all kind of camouflage
Ka kuol bele ka kul ke mi yalan ko fang amang tarakering.
to make the accident or the scene look like artificial.
Isaje ko wo ko nyen wala accident nyen yake ko fenne mi yalan ko amang alandar ko le.
Could you take that again?
O murundi nan kotanke bon ila
To make it look artificial or to make it look like an accident?
ka ke yala ni nyala me yalan ko nimme ya nya boyto accident ngai ba mi ira ko alandar ko wala mba waranto ka iba landina ni nyala me yalan ko ka parende akam.
Yes, to make it look like an accident.
Ka kele kuma mulun ko niaje ba fula accident olem.
Because I can recall how they narrated the accident of Mr. Fati.
Katum hakilo bulatala nung komi ye dantel ke nyame Mr. Fati la accident o karola.
With a truck and a taxi involved.
Moto ba dabije aning taxi moto ndingo.
And in this case, in my particular case,
Ndafana antela karola minkeda.
this is a truck and a van.
Ndomu moto baldi, ndomu moto kanya ndingol di vano.
But I was not sure whether there was a taxi behind me like it was arranged in Mr. Fati's case.
But among kwe ma fo taxi benung ko male komi ye Mr.
There is
Fati
communication between the driver of the truck and the taxi driver.
Chokinyolo abenun jele driver motoba driver nying anin taxi on benyato.
In which instance? The Fati instance or your own instance?
Atila tabang fo iteta.
In Mr. Fati's case.
Mr. Fati la Carola.
So in essence, you using the parameters of similar fact.
Munta wo ibe misalo le dikan wo misalo ko la danya la menketa o odora.
To suggest that what happened in my Fati's case is what actually happened in your case.
Afoko menketa my Fati la tajinto wala kete ifanantaro.
Yes, exactly, because I cannot confirm a taxi behind me to follow me. But then the van that was ahead of me made a sudden break to force my driver to divert. And then the truck arrived at the same time.
Was the truck coming from a different direction?
exactly from the opposite direction.
Wala fomo abota nang nyati ngol.
Mr. Mboj, you would agree that for that plan to work, the truck driver needed to have contemplated
motorbike driver ning abe sula la ning fero la mi alon ko am nyanna sumannale
needed to have known
nyanna jartal pour aya long
that your driver
ko itala driver
would swerve
ba bulo faylale
in the direction
fannala
in which the truck was coming from.
dament yalon ko motoba bina ko fannal
Correct?
onya
Yes, this is, you can make a simple conclusion out of that.
Isa fo mutano ka keta wala nyam.
Because,
okay, proceed.
because the scene of the accident
Atuko accident of fon keta damindo.
is a school or schools.
Safo ko karambungo wala karambungal.
And there are so many school-going children on the highway.
No wato ya tara fana dindin jamal bije mi alam ko ibita kan karambungo do.
You can obviously conclude that when you brake suddenly in front of my vehicle, I cannot go on the right. That's on the side of the traffic.
Sa ibalon nala ko komeni inata duro lota nyato tariake ibalon nala ko kontembulo faino la bulba karola.
You can only go on one side. That is where the vehicles are coming from.
Isitano karado nyinda mala kado motol be bokan wolto kana.
But why couldn't your driver have swerved to the left?
silam muna etela driver ning ma bulo fay kata marala.
No, he swerved on the left instead of the right.
Ate ngoji tana bulubala amantana marala.
No, on the left.
Marala amantana bulubala.
Because there are people on the side of the road, that is the right side.
Katu molle benu wosilo kang wale bulba karo nyinti.
And the area is full of school children, and this was 8:15 precisely.
Ndonging wo ma fo nying karamuta dinu lebe siarun je katu wato le miyalan ko talanse len kata fo talanse na tamuda minute tanni lulu.
I raise these issues, Mr. Mboj, for the purposes of the assessment of the conclusion you are inviting the Commission to draw. For that conclusion to be valid, you have already accepted that the truck driver needed to have known that your driver would only swerve in one direction. That is the direction of oncoming vehicles.
Oncoming traffic. Yes.
driver ning atanya na nyi lonna ko itala driver ning ning atara mobe alhala sifa ning ko naba bulo faila ba bulo faila ni bulu la me alon ko moto mantra na kan o fannala.
The other issue is
wodo menti wala mnyenti ko
that they needed to have known that your driver could not stop. So his only option would be to swerve. And to swerve in the direction of oncoming vehicles. Now,
the analogy I conclude from the accident of Mr. Fati. There is a taxi that they were driving behind him. And this driver was communicating with the truck driver that was coming from the traffic light, Kairaba Avenue.
Taxi driver
And they are giving him the calculation of the distance between the junction and their location. Up to the extent that the truck arrived with Mr. Fati's truck vehicle at the same time at the junction.
Mr. Fati la moto anin trogo ni natana benkak Johnson of Moto Kotu Johnson.
I appreciate that all this can happen. I appreciate that for that to work effectively, there needs to be teamwork by various parties.
Ni ajango fo nyin kusi fanya pour ay ke kuti ferete me yalan ko abe tamala nyanna abe kala kulte me yalon ko mo jamal ba ko nyin ko ne ba ko nyin tamandi kan hakilo kan nyokan.
But for now, let's focus on your own case.
Silanga nyatin ita fangola ko la yemen taki.
And the facts around it.
Andin ko nyin lata nyamen ay an abe ko nyin be me ya murmuru an lata nyamen.
This is very significant because the commission would have to determine your victimization.
Nyin ko kumata bagale katun commission nyin fay si futa ko nyin dandulato ya jube itala ko nyin ibulata nyin ko nyin kono nyamen.
And that would have important consequences.
Andung abina ku kumma bale soro me alon ko abina kala kole ya ku kumma len me alon ko bina futa la dandulato.
So pardon me to interrogate this issue a little bit.
Silo dinna be yam fo dan le bulu pour ngani ni karo ke nyin ko to domande.
You are welcome.
You would agree with me that for their plan to work, they needed to have known that your driver could not stop.
Puru ila nyim fero sitri ngonyim puru ayatama nyanta lonna ko itala drive wonyim ata lono la o lad o dingira nyin.
Because if he did stop
katu ning alota
on his lane,
atela leno kan abe silo men kan
he would not have been hit by an oncoming vehicle.
Moto dota mano la me yalon ko wala bina kan akoma.
You agree?
Yes. I agree with that.
And that by itself raises doubts as to whether this was a plan.
All right. I will agree with you also to an extent.
Yes. And you would also agree with me for us to use circumstantial evidence. It has to lead compellingly to just one conclusion. And you would agree with me that the set of facts described do not lead compellingly to one conclusion. Because of this loophole that has just been identified, that is the possibility that your vehicle could stop and therefore render that plan basically ineffective. Would you agree with that?
Yes, I will agree with you to an extent, like I said.
And by extension, in the absence of any other facts, that goes to the contrary, we might as well consign this case to the realm of speculation or suspicion. You agree?
Well, for that I will not agree. This is simply because the officer, I believe, who has been monitoring me,
just before you answer, my statement is, in the absence of any other facts that go to the contrary, the facts you have disclosed so far can be called speculative or mere suspicion.
in
the absence of other facts.
Yes.
So you agree with that?
To an extent, not conclusively.
So do you have any other facts
silam foyeto e sabat kumo sabatindi do soto leba me alon ko mosa to yandino
which will remove this from the realm of speculation
me yalon ko be kuma ko be bondi la ku kol kono me yalon ko kuma ko ngamoy la miral kumol ronnem
and put it in the basket
ana nana ko nyinta ayake panye kono me yalon ko
of a veritable attempt on your life?
Membay sabatin la ko tonya nyinda nyimu ferelte me yalon ko ilafte ni ola tala.
Yes, I can give other facts in addition to what we have already said.
Please go ahead.
Just like I said, when I moved to Canifing, in December, just before the elections, I want to say it was after the elections. It was within that period, in December, I know. My watchman in my garden at Jalambang gave me a call early in the morning at 4 a.m. and asked me where I am. I said, I'm in Canifing. Well, what is it? Why this call at this time? Said the people who came here looking for you, if those people see you, he is afraid of the consequence. And he said I should leave the country immediately. I said, but why? Said the way they are dressed and their vehicle shows that they are officers. He cannot recognize any of them. They are all wearing face masks. And the same morning,
Did he say whether they were carrying anything?
no, he didn't go to that extent. But the boys, where they passed at 2 a.m. on the way to my compound, they found them on the highway brewing attire. Asked for my compound. But the way they saw them dressed also, they immediately sensed some danger. Said they don't know my house. So which means they went on searching that night on their own. Until they got to my garden at 4 a.m. in the night. And early in the morning, my watchman went to my house, told my family that I should leave the country. And they all started calling my mom, my dad, my sisters, and everyone. Everyone was worried about my safety. I said, I am safe here. And secondly, I am handicapped. I am sick. I cannot go out at this critical moment. But then the pressure mounted. The whole day they were insisting that I should leave the country. And the only way I could calm them down was to agree to their request. I said, okay, I will leave.
Go ko ha mbe bola banko kan.
But then I never left.
Bare nana man na bo banko kan.
I stayed in Kanifing,
Tarta Kanifing.
locked my gate,
Anna bunda
locked my veranda, locked my door, and locked everywhere.
Anna perongo sorong, anna bungo sorong, ngadula be sorong.
And I bought enough foodstuff to serve me for 2 weeks.
Ngadomor jamal le familia lan kon samuna fangano wiki fulakon.
And that coincided with the impasse
And when nata nku nata ben wolen kabrin kare fayo bantanyo sabo membe keri.
until the former president eventually left the country and I was free to go out.
Fo wo president koto membe janata na banko bula mfana nata na mfan soto wala nyama.
Effectively, you went into hiding.
Exactly, yes.
And I can tell you, Mr. Mboj, that
Mr. Mboj,
I appreciate how hard it is for anyone to have to leave his or her country or to go into hiding. By reason of fear of the security forces that are entrusted with your own security.
Dalila membe o kan wala nyindi ko tanko bunda mol mi alon ko wala be o banko kan on wo mol fango ite alon ko ite le wol karfa wol mol pour yete kanta ini la fengol so fengol.
So I am sorry to you and to all those persons it happened to.
Otomba fole ko masa ite fam kundung ani mo ko do ko tangol be me yalon ko nyonku sifal le late kan.
But you would also agree
ani kabi bari be sonna malako
that the two incidents could be just separate.
Nyonku fulol men be yalon ko e kereten kullel me yalon ko kulle e fatata le manka kilindi.
And may not have any direct connection.
Do
you agree?
Well, I will not agree to that suggestion. Because I see it as a continuation of the act after the accident where I still escaped from the accident.
Ebe continue kanne ka kenna sekatuma kabru wato na accident ngo nyinketa fa banda ebe continue kan ku kilingo nyine nom.
But you would agree that continuation you're talking about, the weakness in that argument is the difficulty or the weakness identified in the penultimate limb. That is, it is not conclusive. That act was by state agents. And if it is not conclusive, it means it may not be part of the chain, part of the link in that chain. You agree?
Sorry to say, but I cannot agree with that. This is...
We would leave it at that. I think the Commission would have enough to be able to make an assessment of the facts in order to determine whether this is one continuum or that there may have been a break in the chain. Either way, the Commission would make an assessment on the issue and would decide one way or the other. But in 2006, you did say that you met Bailo and others in prison.
In 2006,
in which capacity? As counsel, visiting? Or in some other capacity?
Could you tell the Commission, please? Yeah, this was in 2010, not 2006.
Mu 2010 sangola kono dia, mu 2016.
Pardon me, that was a slip when I mentioned
Silo
2006.
dino,
Yes,
yamfanya
yes.
uro munne ngola anyalti.
This was after my arrest by the same regime.
Ñing keta watilati mi yalon ko ye muta nung andu mi yake wala mansati no mimbe nun jang.
And I was sent to remand.
Nata nang samba kasoto remand.
Could you kindly give us a brief rundown of the circumstances that led to your arrest?
Ilam fa isa fono nye ko la nyala munne nata na sababu fong fa inati ne samba kasoto.
Very briefly.
Asutiyandi de.
Briefly,
Asutiyandi.
I defended about 10 or more cases.
Lota pruka demarke mole mi yalon ko be diamo kono o diamo nyata fo diamo tang wala mi siata wati.
All from the executive.
O diamo be bodan nang
That is victims of circumstances.
mansala karola wala mol mi yalon ko ye torale.
I'm sorry, they were not victims of circumstances. They were either a victim of some nefarious activity by the state, or they were victims of their own misconduct. So, which is it?
Manke molde me alon ko e dundam mantoro kono ko ifangol la ko la mel la de kan bar molde me alon ko dundam mantoro kono bari me alon ko ya soto mansara karol.
Well, you may be seeking for precision.
A little elucidation.
Yes, circumstances based on their arrest, trial, and convictions.
Wol mi yalon ko wolle lata kabri wato mi yalon ko be mutakang fo enate ne muta yesinde de la killing.
And I myself now became a victim of the same abuse of rights.
Dafona nata bula wol kono mi yalon ko yela nyantoni wala tinya.
Again,
Kotanke.
you claiming victimhood, victimization.
Kanendo ke kan ko ifanan keta molde me alon ko edunda ko la yakon.
And the commission would be required to make that assessment.
Nung commission nying ba abe sulala la pour ka ko nying ka no masata ka jube.
Which would implicate having to know the basic facts in order to be able to assess whether this person qualifies as a victim under the circumstances that have been described.
Amen dia lon ko commission ba jube la ka yirika ka jube fo ka nyimare nyim fo futata to kunku ngotol me ya lon ko mosa kuma ni mo mole mo ya lon ko ay kole ya soto e ka me ye victim.
So tell us the facts.
Silang to nya fo nye ko fo
What
nye
happened?
muneketa.
Why were you arrested?
Mune ya sabu ye bulole kan ye muta.
This was after the second treason trial, the first one being the Bunja Dabo case in 2006 to 7.
Fenneti mi yalon ko wala kata no wo jamfa jawo min sitata no mi yalon ko bunja dabo da blata kono le no.
And the second was the Lantambong and Sajo Fofana case in 2009.
Dum fana fulanjongo nyi waleng lan tambong anin sajo fofana la diamo nyinte mi yalon ka kata 2009 sangola kono.
Were you part of the defense team in the Langtombong case?
Fo idabe mol kono ba wol me yalon ko wolle be loro nyin tumi mol ye men yalon ko lan tombon na case lamba.
I was with SM Tambido. He was defending Lantombong and I was defending Mr. Joe.
Daning SM Tambido.
Chief of Navy Staff. What's his name? Joe. The second.
The lota lantomboye, the lota moye mi yalon ko.
Sajo Fofana.
The lota sajo fofana.
Yes. I was representing Mr. Fofana in the case.
Good. So, and then after they were convicted, of course.
Munda okola inarne besoro.
So what happened to you?
Sila muna narana kete fango kundi ngola.
Well, I was representing a client.
Tabe loka mole mi yalon ka dia mole sodono.
I can say pro bono.
Aka na dolonga manjo fenna.
And after preparing all his papers for him,
Kabinata wo mari nyingala kaitol be dedai.
I called him for him to come and sign.
Nata ka kili pura nanang pa ka kaito nying ka hatim ka sign kala
Because
signature.
he has a power of attorney from his father, who is an old man.
Kato ko ay kaiti la dedata mi yalan ko wole baitan la ko kitio nyanta kela te se lono a fama en to yala wo kaito de data arkato wato ya tara fama mo ke baltino
But
totally
he was, according to him, he was all the way in Tujereng.
te memfo ako wato atebenu fo tu jereng
And he is on a contract.
do wato ya ta do ko wichola
And he cannot leave that job to come to the court to come and sign his affidavit.
ako kang ate bulano wo do ko wichomi ya tiala ka bona woto kana kiti dulato pro ko wo kaito nyinta ka sign.
He said his father is illiterate
Ko afama mang momolti mialang ka mangkarang
and he doesn't sign his thumbprints.
lum fana mole mialong ko abuka signing ka aka tombole laje
And he pleaded with me
natana ndani
to thumbprint that affidavit for him
natana ndani pru wo kaito nyin ntasa tombo
because of the urgency of the case. He wanted filed as soon as possible.
atuko mi woti na wala nyinte ko abe hamerin tariyake pru wo kuma ka adia monyin nse kaito nyimbe dundi kiti dinkirato.
I gave the processes, I mean the papers. The interpreter knows what is a court process.
Of course.
Kana sola nying walo ne ka fo mi court process wala kaito ko kiti dula ila kaito mi yalan ko
To my clerks to go and file.
so nata na di naklago wala praeta dundi kiti dulato.
I did not even tell them to thumbprint it.
Ma fo fang pour ye tombo kala.
I wanted it filed without a thumbprint.
Dafta nung dundi kiti dinkirato ya tere man tampo laka.
But when they got to the commissioner for oaths, then Mr. Sambu,
Bari wato
the High
mi
Court,
alonko ifutata mo mi alonko wo kaitol nying wala nyanta ka fasa kala sano keje
He
ka
said-
fo mi Mr. Sambu.
the affidavit is not signed, so I think it was filed already.
Ngamra num fa nga dundi la foka pare brate
He said the affidavit is not signed and or thumbprinted.
ko wo kaito nying ima sign wala man tombo laka.
Then I had a new member of staff
Wato ya tara ngamo kuto sodo mi alonko abudo ko lam
who doesn't know the implications
mi alonko amalon fang una woke wobina min wulula.
of thumbprinting an affidavit.
Atenada na ka wo kaito nyinta ka tampo kala tampo laka.
And she volunteered
Da na tana kala tara mo ma
to thumbprint the affidavit
ka wo kaito nyin fanata ka tampo
and get it filed.
na tana dundi.
After the filing and the dating and the service of the process,
Fo kabrin wato mi yalan ko nga dundi fo ina tana lungo di anin fana wato mi yalan ko nyanta ka kaito nyin di mo do fana la mi yalan ka dabe kiti okon.
the same client who pleaded with me to sign and file it on his behalf
O mo kilingo mi yalan ko na kliano le mi yalan ka en dani ako purun sa tampo la kan andunga dundi fana kiti dula
turned around
na tana murun koteng
and said he did not authorize me to sign that affidavit on his behalf.
na tana fo koteng ko ate man sembo dintela purunte wo kaitol mi yalan ko ate la kalikumol le ba kono purunte na tombo la kan.
He insisted on withdrawing the application before the court.
Natana balanko ko ay wo kaitol min dundi kiti dulato alafta ka bondile.
After withdrawing the application already,
Abra nata fire wo kaitol nyim bondi kiti dulato.
I believe he got a link with the same person who is monitoring me. That is because they come from the same village in Jambanjele.
Atuko latala ko mole mi yalon ka ni mole be chokinyolo kono wo mo mi yalon ko wole be buntala ko no masata kan kata te ne wo mo kilongo ni tol be mo jambanjeli koleti.
And then he had an opportunity to get me arrested
Wato la nata na harje soto pro yente muta.
and ask him to go and report to the police.
Nata fire ko praeta kuma ko nyim futandi police olma.
Well, Mr. Mboj, if the fox is hunting you
Mr. Mbol ni mo soro mi alon ko abede makam.
and you come and put your hand in its mouth,
Ina na ida bulo o mari da kono.
how would you feel if you are bitten by the fox?
Tete bo ko nyin tala nyaade le nango mari king o fengo nyi king.
You
Yeah.
called for it, didn't you?
Yes, to an extent, yes. If
Ania
you
jibi,
can anticipate that this client will come back and say he did not do, instruct you to do that.
Ni nata kuol be yire ka yajibe ko me nyimmo kilmo mi anaklia no la ba murra ko mala ko den kana fako atema wo yamal ro nyimbe.
But with all due respect, Mr. Mboj, we have to call a spade a spade. Let's agree that let's take it for granted that you are being haunted. They were looking for a reason to get to you. You knew this fact.
That is correct.
Now let's come to the affidavit. You knew it was irregular to file a purported affidavit because it would not be an affidavit without the signature.
I am aware of that. And this is why.
Let me come. And obviously, you knew when you gave it to your staff to be filed, you knew fully well that even if the papers are accepted, the affidavit will be thrown out because it is irregular, it is incomplete.
Without a template or a sign.
Yes.
Yeah, that is an incomplete affidavit.
Exactly. And you knew it would be thrown out. And the effort would have been ineffective.
Yes, but I would have relieved the pressure on me to get the document filed.
Yes, but step by step. But even at that, it has legal consequences, and I don't want to enter into that. And the thumb printing of the document was uttering a forgery. Just looking at it at the strict interpretation of the law, that is uttering a forged document. With all due respect, I'm not suggesting that you did that. We're just looking at the basic facts. What happened. If it was done by your clerk, it was uttering a false document. You agree with that?
Yes, I agree with that. That is correct. That is, I will add one condition. If I had given the instruction to do that.
We are talking about the act itself.
The nature of it. I agree with that.
And this uttering of a false document was done by your chambers, by your practice.
And that is why I took responsibility for it.
Exactly. So having taken responsibility for it, you have taken responsibility for a crime.
Knowingly, yes. Consciously.
No, but it is consciously.
No.
Okay, we will come to that. These documents were filed, correct?
Surely, yes.
And there would be returns to your office.
Yes, that's correct.
And as counsel, it is your responsibility to examine your returns. To ensure that your documents are in order.
That is right.
And with due diligence, you would have seen that your office uttered a false document.
Yeah. That is right.
And with that, you would have been responsible for that, for the uttering
of the document.
Wakang itele ba lon kunto duno nyintala pour ka kayti bande me yalan ko amanke kayti sahayare ngolti amanke
That's
kayti timbare
correct.
ngolti.
I took responsibility for that.
And that itself means you are responsible for a crime that has been committed.
Itele lon kunto duno ta bara la me yalon ko bara tilimbalole kule me yalan ko amanke ku kendoti.
I wouldn't agree with that. I took responsibility for a purpose.
Not a
crime.
So you took moral responsibility, but not legal responsibility.
Yes, because accepting responsibility doesn't amount to criminal responsibility.
I will not get into a legal debate on that. But you would appreciate that whether you are legally responsible for that crime or not is a matter for final determination. Of all the issues in view of the evidence. To see whether you have a defense or not.
And
either in order to determine whether the evidence is sufficient to attribute responsibility for you. You agree that would be a matter for final determination.
Yes, that is the reason why I was charged. And I was taken to court.
And
for determination, yes.
Exactly. So therefore, these intermediary steps of investigating you and charging you were regular. That is what was expected.
Well, this was not a case that was investigated.
But okay, let me rephrase it. The intermediary steps of getting to that final determination, be it investigations, be it arrest, be it laying a charge, and be it arranging you before a court, you would agree that all these steps are regular. And are expected.
I can say they are expected, but not regular.
But how can you expect it if they are not regular? These are prescriptions of the law.
Yeah, there's a procedure for those steps, procedural steps to be taken before your arraignment.
Janning silul tarambulo lebije miliyalon ko wolek nyanta kata fo jane wato miliyalon ko bafala yelo ndikiti o nyati
not in this case.
Kindly tell me what are the steps.
When the complainant gave his complaint to the police,
wato miliyalon ko moni miliyalon ko wol natala kibaro di polisol.
I was summoned in his absence.
Yento commande la tema kalamuta.
On a Thursday.
The
next day,
I
was before the court. In the morning.
But Mr. Mboj, you would agree with me, all the things you have said point more to the efficiency of the wheel of justice than to an abnormality in the process.
We have seen experience of cases that state has interest. Fast tracked.
Nga jele
So
diamol mi alon ko ki mansa e sulo soto diamol min to nga jele ka kitol ka nyama ka triya nyami.
So your beef is that it was fast tracked. But that is in fact what we all crave for, that in the justice system everything works so fast, so effectively. That people are tried within a reasonable period of time. People are tried within weeks in which after the criminal conduct has been disclosed instead of years. So all the criticisms you have raised are not in fact procedural errors. You agree?
Yeah, you have not finished because when I was arraigned for a matter which is not an arson, not a treason, an offense that is a bailable offense, and then from your arraignment, you were remanded in custody straight away and denied the right to bail. That was not what is expected and contemplated of a lawyer. But there are other circumstances leading to that, which I have not explained.
Okay, we would come to those.
Yes.
So let's take it step by step. Let's first talk about the arrest. Was the arrest lawful? And be careful, your pupils are here. So it's your responsibility to teach them the practice of the law. So tell us whether the arrest was lawful.
Yes, I will believe that is so.
So there is no complaint about your arrest. So the issue now is the detention. The remand.
That is right.
And what's the problem with the remand?
I know as a matter of fact that my arrest came shortly after the case of Moses Richards. No.
What is
Moses first. And then when the GBA, that's the Bar Association, called an emergency meeting, decided to protest by boycotting the courts.
I
disagreed with that. And I said no. And I suggested the procedure for impeachment of the president.
Of which president?
Jame, of course. Is by matching and filing a petition to the National Assembly. And I said this with a caution that we have informers in our midst. And I'm saying this, and I know the next day it will be at the State House.
Are you saying this to suggest that
because of my pronouncement, yes,
there was a motive,
for my
a reason to want to have you behind bars?
Certainly, that is not all. I have other daring challenges that I don't think anyone can dare to.
Amanke woda mati kul keta nala mi yalon ko keta ku balete mi yalon ko mamira moba hanyela ko ku sifal fonta.
But you have no evidence to suggest that Yaya Jammeh put you in jail because you said that. You only suspect.
It's not a suspicion. This is a matter of fact. This is a time when the trial magistrate, we all know, was a Nigerian. DPP then called Mikhailo. It's also a Nigerian. And we all know this is a case that can be prosecuted by the police.
But do you agree that the IGP prosecutes a case on the fiat of the Attorney General?
Ibari sonta nyimala ko IGP police la fanna ka case le kitinde me ya lonko kanne me ya lonko akabo Attorney General lebu.
I would say yes, matters that the state has no interest.
That is basically the law. Whether interest or no interest, the prosecutorial authority is vested in the DPP under the supervision of the Attorney General.
That is correct.
That is the law. Perhaps we can avoid a lot more polemics by just agreeing that the presiding magistrate had the discretion to remand you in custody. You agree with that?
No, I don't agree with that.
Are you suggesting that the presiding magistrate was obliged to let you go on bail?
Oh, ilafta fala ko magistrate o membe siring o kitio ila o kitio nyinkuna abalantala purukal bail dila ba.
No, was obliged.
Nyanta bail dila le, sorry.
He's not even obliged.
Exactly. And by not being obliged, the presiding magistrate had a discretion.
He had
no discretion under the Constitution. Bail is a constitutional right under. It's a constitutional right under the Constitution, but it is discretional under the CPC, criminal procedure.
But this is precisely what I have just said.
No, the Constitution supersedes the CPC, and that makes it a right. It's a fundamental right, and not a discretion. So that's where I disagree with.
Okay, let's do it this way.
Sorry, the interpreter is not following me.
Yes,
sorry.
That was a bit too legalistic. Maybe
yes.
That's the reason why they got lost.
Yes.
But let's do it this way. Mr. Mboj,
yes.
You agree that bail is not an absolute right.
It's
not an absolute right.
It's not.
It's not an absolute right. I know you're thinking, Mr. Mboj, but it's not such a difficult question.
See, it is technical. I know I'm before a commission and I'm before learned, experienced people here. People are watching and listening.
It is not an absolute right.
No, absolute is a relative term. It's not...
absolute means absolute. There is nothing relative about absolute. Absolute is as absolute as the word.
Because the reason why I don't want to agree with that is because... Under the CPC, it is a discretion. And there it is not absolute.
But even in the Constitution,
it is mandatory under the Constitution, Section 19.
To grant bail.
It's a fundamental right, and that right is mandatory, couch in mandatory language. If you bring the Constitution,
Okay.
Section 19 sub 1
I have
says
just-
that no one shall be deprived of his or her liberty,
Yes, but
except
and by saying except, what
in
does that mean?
accordance.
By
In
saying,
accordance.
okay, just a moment. By saying except, you have removed it from the realm of it being absolute to import some derogation.
No, I don't want to agree with the use of the word absolute.
Man la fi sonna ka fo doro mi
Bring the
anyanta.
Constitution.
I will-
Go
I
to
will-
Mr. Gay Show. He would give you the
I
Constitution
will
and you
equate
bring
it.
it.
I will equate it between
Mba
between.
Go to Mr. Gay
Mba
Show. He
jibela
has the
fanal
copy.
mi
He's
na wala
sitting
nyiti
right
ko.
out there.
I think he's in the witness room.
Okay, go to the witness room. He's there. This is very basic, Mr. Mboj. It's either these fundamental rights are not absolute. There are derogations. And the derogations are the exceptions that apply to them. And because there are exceptions, you cannot call them absolute. This is basic principle of law, isn't it?
Surely there is a line, and a thin line of distinction between the mandatory and discretionary provisions of the Constitution and the applicable general law, that's the CPC.
And the only mandatory provision you had with regards to bail was the absolute provision that for a charge of murder and treason, they were not bailable. That's the only absolute provision, because there's no exception. The rest of it was not absolute. The rest of it was based on the discretion of the judge after evaluating all the evidence to satisfy the judge that this person is not a flight risk and that this person would not tamper with the evidence if he or she were to be released. Those are the only two conditions in which a judge is judiciously able to deny bail. Agreed?
Well, yes, there are laid down conditions, obviously,
Sartol bi jele mi ay wala landi
for you
wo
to
fanna.
satisfy before you are granted bail.
Wo sartol nyingi nyanta ko wol be timandi la
But
jani
if those conditions are satisfied,
natara wo sartol nyi ya be timandi la.
Let us first agree on the law.
Ilanga ben luado folo.
That the magistrate had the discretion
O magistrate ni wala kidi tela nyin ko ay sambo sotole.
to grant or not to grant bail.
Beldi waranto akana beldi.
under the general law, yes.
Loi be to wolem.
And under the Constitution.
Anu loi buku ba nyim fanan koto.
No. The discretion will be eroded with the mandatory provision of the Constitution.
Well, with what you are saying, Mr. Mboj, it therefore means nobody can go to jail.
O de be mem foka Mr. Mboji wala nyindi ko to mo nyanta la kasoro.
No, I did not say that.
More for.
Well, if it is absolute,
Ninga tra nyanta le.
if it is absolute that everyone has an absolute right to liberty, it means no one can go to jail.
Ya jara ite ka fo nyamen ko nyanta le ko mobe mo nyanta nyanto solo pour ka fan soto.
If you build in the exception, except where the person is lawfully convicted by a court and sentenced to a term of imprisonment, then you create the exception for a person to go to jail. Here is the Constitution. Look at section 19,
Section
personal
19.
right to liberty, and read it.
Je karamba.
I'm familiar with this section.
But I am not so familiar with this section because I haven't read the Constitution for the longest time. But I can tell you with 100 degree of certainty that there is no law that would give an absolute protection for the right to liberty. I can tell you that.
See, if you look
Take a look at it.
If you look at the language,
Just take a look at it and read it.
that's what I'm saying. If you look at the language of section 19,
Yeah, jiber.
Just read it out.
every person shall have the right to liberty and security. No one shall be shall be subjected to arbitrary arrest and detention.
Arbitrary arrest. So let's underline arbitrary. Arrest and detention. And what does that mean? No one shall be subject to unlawful arrest and detention.
Yes.
And that means anybody could be subjected to lawful arrest and detention. Your arrest was lawful, you accepted.
I agree. It says no one shall be deprived of his or her liberty.
This is unlawfully. Unlawfully.
This is the third time that the word shall is used in section 19.1. The third time it says shall, which is mandatory. We all know that.
Mr. Boj, you are putting emphasis on the wrong word. It is not about the shall.
Exceptions are there.
Exactly.
Exceptions are there, I agree. If you satisfy those conditions, it becomes mandatory. I'm not comfortable with the use of absolute, because no right is absolute.
Exactly.
I agree with that. There is no right which is absolute. The issue is between whether it is a discretionary right or it is a mandatory right.
Yes, but
if you satisfy the conditions, then it is mandatory.
But no. If it is discretionary, it implies that it is not mandatory. It's simple semantics.
There are two different languages when it comes to the right to bail. We have the CPC, which makes it mandatory, and I am saying that the Constitution makes it mandatory.
Mandatory for what?
If you satisfy the requirements laid down for your bail, for the granting of bail, it is mandatory. You will be refused bail only if you are a flight risk, you will interfere with the witnesses, or
evidence.
Something of that sort.
Yes.
Yes, then you are not, that is where the discretion comes in.
But this is what I have been saying all the time.
Yes.
Okay? The magistrate had the discretion. Right?
Magistrate on yesembo
To grant or not to grant bail.
Beldi waranda kana beldi.
All right? And the discretion was to be exercised judiciously.
And
the judicious consideration was flight risk, tampering with witnesses, or tampering with evidence. I see you nodding your head, so thank you for agreeing.
No, I agree with you.
Okay. But if you did earlier on, you would not have had all this legalistic polemic.
No, but I'm not comfortable with the absolute word.
Well,
right, which is absolute.
Well, you used the word absolute. No. You said this was absolute.
No.
Okay, all right, then I misunderstood you.
The language of the Constitution is couched in mandatory language. That is, makes it compulsory for you to have bail if you satisfy the required conditions. I agree.
Okay, so the judge exercised the discretion granted to him or her, or the magistrate, and assessed the evidence in your case, and decided to remand you in custody. Did that happen?
No.
What happened?
That is not the case. After the reading of the charges, normally you are entitled to apply for bail. I was not given the opportunity to apply for my bail.
You would agree with me that there is no law which says that immediately upon your arraignment, the presiding judge or magistrate shall give you the opportunity to immediately apply for bail. There is no written law on that. You agree with that?
Yes, I agree. Then I will
Okay, then
explain.
let me ask my next question.
Bari ngena ngana nyini kar do fana nyini kana.
And by deciding to remand you in custody,
Wo kiti kundula nyin ka kangota pour ke samba kasoro ke sindije.
the presiding magistrate has not deprived you
Wo kiti kundula nyin amebali
of the possibility
ko ko la mi alon ko isikeno
to apply for bail.
pour isi daniro ke pour belero la.
You agree?
Isonda wala.
No, I don't agree with that.
Manso wala.
Did you apply for bail at any stage?
Way daniro ke belero la ko la bang wati o wati to bang.
I did not.
Ani
But wasn't that a matter of choice?
Bari fo manke kuti me alon ko atudete le bulo isi asa keno.
It's not a choice, but a right.
manke ndi anyo koto.
What I'm trying to trying to explain, if the matter is proceeding to trial on the same day the charge is read,
na tara lungo nyim fom yalan ko ye tumiri ka kango nyin karanya ndu wolun kilongo len kitio nyin kontineta
before the adjournment of the case,
jani be sawondir kala kalo la dota wolungo
the
nyin
trial magistrate or the judge is mandated by law to consider your right to bail.
mi yalon ko kitio be wala bulu kiti tela nyinga nyanta ka jiber ka ko la mi yalon ko wala nyante yesse dundir ke no pour ye bail soto.
Mr. Mboj, you know that the wheels of the criminal justice system are moved by emotions. They are not just moved by wishes or dreams. They are moved by emotions.
Baro la lua la ya ko lande nyamenta ni be ko daniro le kala nyin sifal le ka daniro ke ni safiro le ba fala me moso ni bukata ni miral ko ron na ni dianya ko.
Is that not the case?
There is a procedure in every court.
Yeah, yes.
But answer the question.
Not only by motions. Motions apply in superior courts. This is a court of summary jurisdiction.
But it's a motion.
You don't have to apply by motion. That is a formal application.
But it has to be an application.
Yeah, exactly. You have to bring an application.
Okay, good. So it's not just a wish or a dream. There has to be something that would trigger the process, correct?
That is, yes, correct. If you are given the
did you apply for bail? Did you trigger the process by applying for bail? I bear in mind your previous answer. Did you apply for bail?
I said before I will apply for bail.
Did you apply for bail? Just answer that question. Did you apply for bail?
There is a procedure in court.
Just answer the question.
I was not given the opportunity to apply for bail.
But all it took, Mr. Mboj, you are very learned in the law. All it took is for you to say, Your Honor, I wish to apply for bail on the basis of section 19 that's all you needed to say. Isn't that the case? Isn't that the case?
You can do that.
So okay, no.
Good. Was your mouth gagged? Was your mouth gagged?
You can do that when the court finishes recording what it is recording. You cannot interrupt a court. That is unprofessional.
But that's what we do every day, Mr. Mboj. We interrupt judges. We say things. Sometimes we even talk over each other. This is normal.
I agree. But yes, if a court records your plea, after your plea, and sends you to remand without giving you the opportunity to apply for bail, and you are saying that whether my mouth was gagged, I was not gagged, and you know that, because in court, nobody can gag your mouth.
Okay, so the reason why I ask these questions, Mr. Mboj, is to determine, because what we are mandated to determine is the unlawfulness of your detention.
dari lo me asab ngay nyinin karo nyinin ka wala nyindi ko ka tun do go men di tan tolla wala nyindi ko ka kol kisi ka jube mutaro men kede la wala afani luanta yale mbam fo munen.
And the test would require us to examine all the procedural steps.
No koto boro nyin me woyen kanin nyin na puru nga silol nyin be jube ka jube fo silol tata la me alan ko nyanna woldel tala janni be sambala kaso.
If the police had arrested you and bundled you and taken you to straight to mile 2 without any paper, as has happened in many cases,
ning ayatra police oli mudal ro ye kafu nyomare yesamba kasi bumba to koy ka kodol ka nyame warra kayti o kayti de je ka do lakol la nyame.
then we say this detention is unlawful.
Ren sa fo no wota ko de la mutaro nyi wanta ya mutaro lem.
But you were taken before a court.
Bari yete samba kiti te la nyati limola.
And the court sanctioned your detention.
Andun court le nata na kangol kuntu purita la mutaro nyi na ke samba ke sindi dulakile.
Is that not what happened?
Wala manke ba.
That is what happened, but
Wala
we
keta.
all know.
So then, because that is what happened, that is what the law prescribed.
Wala men na ko lata wala nyama itela karo.
That if you arrest a person, take the person before a judge within 72 hours.
Yes, and then the judge
will decide whether to release you on recognitions or to detain you.
Jel tom kiti tela nyi wala ba su tela fo ajarta pour que bulaba warando fa be bulala ni kula ka kuma kan kalimol le kambanga ning.
And whether the judge was right in the considerations or wrong does not mean that your detention was unlawful. The mere fact that the judge considered the issues and arrived at the decision whether to release you or not rendered it lawful. The judge could have made a mistake in the application of the law, but that is a matter for appeal. On this particular occasion, Mr. Mboj, it looks like it was regular.
I beg to disagree with you. I don't want to argue legally or my arrest and detention, whether it's legal or lawful or
Mr. Mboj,
that is for the commission to decide.
Yes, the commission would make its finding on these things, and if you, I don't know what that finding would be, but in the event that they made a finding with which you are not happy, you could utilize the provisions of the rules of procedure to deal with that issue. So you were sent to detention.
Yes, indeed,
whether lawfully or unlawfully.
What happened next? We will indicate to you that it was just a kangaroo court. Why? Because if you are detained on Friday, on Monday you are supposed to appear in court. And before you appear in court, you are already granted bail. Is that a court? Is that how the court works? As a lawyer, we all know that before you are granted bail, you have to stand before the court.
But even if you impugn that decision, what you are impugning is the release and not the detention.
Even the detention is wrongful. As far as I am concerned.
Your difficulty, Mr. Mboj, is to pinpoint a legal reason which would be the ground to base a finding that the detention was unlawful.
What I'm saying before this honorable commission is that not only the detention, even the arrest, the detention, the prosecution is all politically orchestrated.
Commission bunyari ngo nyati ngola wala nyintiko na muto ani wadom na yensen samba kiti dinkirat ni abeji be fenne mialan ko politiko le dabula takon.
And that may very well be true.
That is what I'm saying.
Yes, but the fact that It may have been politically motivated. Does not mean that the process was unlawful. You agree with that?
No, I don't agree, because you can use the due process of the law to abuse the same process. And that has been the order of the day. The law is being used to abuse people's rights. And that is what happened.
What I can agree with, in your case, is the executive had a beef with you, and you gave the executive an opportunity to deal with you, and they used the law to deal with you, to produce a consequence that you did not wish for yourself. But that does not mean that the process was unlawful.
Well, I will not agree with that. Because...
But okay, let me ask you this question, Mr. Mboj. If you had killed somebody, God forbid, I think we've said that in unison. Okay, let me use another example. Okay? If you had hit somebody.
Can you reverse it? If you had hit somebody.
Yes.
Yes.
Yes, that's right.
Yes. Example of yourself.
Yes. If I have hit somebody.
Yes.
And it is understood that this is a crime.
Like an accident.
No. No, if I deliberately do it, it's a crime. Correct?
That is right.
Would I be entitled to arrest?
Sure, certainly.
Would I be entitled to detention pending trial?
Yes, that's a right. On the prosecution, they have a right to 72 hours detention.
But even after the 72 hours, would it be procedurally correct to bring me before a magistrate or a judge and have me detained?
No, you can be brought before a court of law, but you cannot be detained.
You cannot be detained.
No, because
is that the law that is practiced in this country?
See, we are dealing with a situation that we are all aware.
I'm not talking about a situation. I'm talking about the application of the law, straightforward facts.
For instance,
does a judge or a magistrate have the power to detain me in the circumstances described?
If it is a misdemeanor and it is a bailable offense, you are entitled to bail.
Being entitled to bail does not mean that I will necessarily and must get bail. You accept? It means I may or may not get bail. Correct?
It depends on the facts.
Exactly. So it depends on the facts. And since...
Just a minute.
You want a few minutes, Mr. Moon?
Yes.
Okay, please, by all means.
Comfort myself, Mr.
Of course, by all means. Perhaps, Mr. Chair, we could just take the break now, the lunch break. Yes, we take the lunch break.
You're continuing with him?
When we come back, I will take only 20 minutes with him, and then we'll finish.
20 minutes or 10 minutes?
20 minutes at most. I mean, I can leave this point and just leave it to the commission to decide. But I just wanted to ensure that all the relevant issues for consideration has been brought out and that he knows that those considerations are being taken into account.
No, I'll leave it to you. If you need to continue with him
20 minutes.
briefly, we can do that after the 1 hour lunch break.
Yes, Mr. Chair, 20 minutes most.
So we can do that, but let him just come back and then I'll respect him and honor him with the announcement that we will go.
He can be informed.
I'd rather do it, yeah, let's wait until.
Okay, all right, no problem. Thank you,
I
Mr.
don't
Chair.
want to close the thing in his absence.
Much obliged, Mr. Chair, much obliged.
I'm sorry about that, Mr.
No
Chairman.
problem at all. It's call of nature. We will take a lunch break and then come back at 3 o'clock. So meeting is adjourned. Thank you. Welcome back, everyone, from the lunch break. Council, if we're ready to continue, you may please proceed.
Thank you, Mr. Chair. Welcome back, Mr. Coach.
Thank you.
Stamboje bismillah koranke.
So I want us to go past the issue of your alleged victimization. I do believe that the Commission now has sufficient facts to be able to make a determination. As to whether, based on the facts disclosed, whether or not you would qualify as a victim. On the issue of your arrest and detention. But let's now continue with the issues around your arrest and detention. You told the Commission a little while ago that you were granted bail the next day. Was that the case?
Sorry to say, but it was not the next day because it coincided over a weekend. It was between Friday and Monday.
So you were ultimately granted bail?
Yes, before I came back to court on Monday.
So how was the case disposed of?
A lot of things happened before the conclusion of the case.
And those would be most interesting for the Commission to hear.
Because at the time of my prosecution, I was defending several cases, including the case of Dr. Aissatou Touré, the case of Klute Mane and Mamatar Seka, and the case of Sidi Bojang at the state. Sidi Bojang But prior to that, it is important to mention during the treason trial of Lang Tombong Tamba and Sajo Fofana, they were brought in chains. And when I raised that complaint in court that they should not be chained in court, the judge's reaction was that the case before him is not about chaining, but about treason.
Kiti tela ni ala jabiro kata mente wala nyindiko ako ye minna tanya to kiti yola kalola amanka komi ye blol ni singol min city bari komi ye natimi na wala jamfa jawti atabelola wala kam.
And then I filed a writ of prohibition against the state.
Natana dundir ke ka itandi ko mansala ko komi ye wo minke pour ye bondi je kana ke wala wo bulusitol nin kukuton.
To stop putting the accused persons on chain,
because
it is a violation of their right. And it is obvious to me that this was also reported to the then head of state. So putting up the facts and circumstances surrounding.
And did you think that that would not please the head of state? That you have filed a writ of prohibition?
Prohibition.
Prohibition, yeah.
Yes, certainly that will not be pleasing to the head of state.
Niya jibe wobekela kaneti wala kumaliti miyalonko banko nyatonko wato wotekela kuti miyala be diala.
Because those chains were with his consent.
Katuko wo sitol miyalonko yake o molla ke blo ni singol city womu feneti miyalonko yaka tella kuokang.
And obviously, we all know that he doesn't want anyone challenging his authority.
Mr. Chair, I just wish to remind the Commission that the Commission had seen the letter written by President Jawara during his time on the issue of putting people accused of crimes in this country, putting them in chains. And he had decried the issue and banned, actually, and prohibited the use of chains in this country. I just bring that out for the Commission to reflect on these two different approaches and the different ways in which rights of this nature are respected or flouted, for that matter.
Was that law in force when the witness dealt with this issue?
It was an executive ban, pretty much, that in this country we should no longer use chains on prisoners or detainees. You can use a handcuff, that's fine, but to use chains, cuff the hands and the legs, and I mean having a chain in between and all that, like they do, for instance, in the U.S., like people charge. Yeah. I mean, that there was an absolute ban for that. But anyway, I just raised it so that the Commission.
No, it's interesting. Witness, did you cite that law in your petition?
Yes, I did, Mr. Chair. Funnily, my application for prohibition was brought before the same judge who was hearing the treason case.
What?
Interesting.
Yes, my application for prohibition.
But he had already made a pronouncement on the issue.
Yes. And the application was brought before him as well.
Strange.
Interpreter, is he with us? And then,
Chairman,
yaman kamem volem nyindi ko sedo fo ite o danir bundal men ke ya safe ya dundi kidi bundado fo kidi o nyinata na tale bambare sedo kamem volem nyindi ko men na fam ko nyim fon manende do mande wala nyindi ko danir bundal ni ngaw men dane pour o mol ni be nat la kiti o le kakari bulol ni singol ke ka joloy duila o nata na di jojo la me alongo kiti te la me alongo ngaw kuma kon folo men fo men ngaf akonye ko o manke ki tumirde men nat ata nyati no men nat ata nyati no wala nyindi ko nyimoli la fa jam fa jawle kele wala nat ata nyati no amanke nyindi ko ye bulol ni singol men sidi wala nata nyati no silang inata na nyi dandir bundanya ay safaro menke ka fa me application no inata no nata kiti te la kilingol nyati ngola wala nata kul fa manende ata fe.
And then the leave is required for the hearing of all prohibitory orders.
Mimbije wala nyinti ko ni lefta ko wodi amo sival dundi inyanta kiti dulami ay lefta ka dundi wol nyanta ka sonna folo pour wo kiti yo sinananje jani bo wo kiti sifa dundi lano wala kaytande ko kuol mi alan ko wolebe kering wo kiti ko na ka mol mi alan ko sobi moli ke bulol sitani singol e ke nanti nan kiti dinkrat pour isa sambo wo kiti oto ise wo ko baya bo.
But the trial judge refused to grant leave.
Bari wo kiti tela nying mi alon ko kiti o nyanta tala wala aman silo walang pour isaje so kiti o nyin dundino kanata tele kiti bon
on the basis that that is a matter of security and that's an internal matter and not a matter for the state, for the court.
ako mo fenneti mi yalan ko tanko bundala ko lem anda manke bundati mi yalan ko kiti dula haji soto walal.
Your application was dead even before it was conceived.
Mondete dari la lesa firo nyinga keta kule me alonko aman nafa sor hanin janni wato men janna fudala fudu nyana fudala dal.
Exactly what happened.
And then
yes,
what other things happened in between?
There was a lot of confusion about my case. Some were for my prosecution and others were against my prosecution.
Dol bije wol sontale komi benketi ndika nyame sontalal ba dol fana bije wol mon songi benketi ndika min.
Were solutions offered to you, options?
Yes, solutions were offered as regards the settlement or withdrawal of the case from the court.
Ye kol na tinyati no la mialon ko nse sonno wala la isaje wo batin la no di wodi amoni sa bondi kiti dulato.
And you know that is an executive discretion.
Yes, and the only way that you can convince the executive to withdraw a case against you is when you are compliant with the orders.
Yalon silo mi yalon ko eso da maltano pour ka mi yalon ko wolle wo nyaton kolde comme président ngim fon pour ya sondino e nyanta kala molete mi yalon ko atebella frin ko ko le nyanta ka son sonala e manyana walang na la ko nyato.
Or when you can show that your prosecution would be an exercise in futility.
For warando ya itandi ko itela kiti ndronya be kala kiti lete me yalon ko nyato sining abina kala kiti gensan wallet.
Exactly, I will agree with that. Yes.
So you had two options.
Munta kufula wale beibu.
Go to bed with the executive.
Ila ining nyaton ko la kan.
Or you show that your case is so strong that it would be foolish to continue to prosecute you.
Waranto ya itandi ko ila kiti on tumiro le mel kan kule me alon ko bambambate kan andu abekela kensen de pour kete kiti.
Which option did you choose?
Ite jumale tombo nyimfulol kono.
Go to bed with the executive?
Taete la ining executive la kan
or dare them to prosecute you?
Waranto ye kiti ndi.
Well, I eventually ended up with compliance. That's the second limb. Because
is it real compliance or going to bed with the executive?
Some fan wala ba ina rawle tombo ban fo ina na ta iglale ban inin executive wala santon ko la kuma kanwati.
Well, sometimes you try to maneuver your way out of the case without actually going to bed with the executive.
Yeah, jawato dobi je ka fanna tale mi alon ko ibole kala no fo ye dabondi wala yo keso ni ya bondi ye ba kono atala fang inin nyumoli ni manta ku imni manta ku kling.
To become a political prostitute or to fight? Which one did you choose?
Ilang ibina kala politiko multi me yalon ko ibekela momo nata.
I mean, when we lawyers speak like that, it does not mean in the derogatory way. It means accepting some advances which otherwise you would not accept.
Ni to lawyer ni diam do nyam wala mi manke nyindi ko ma nyim firin ko modo ya mi nyame comme ni diam do ye ko le nyaato ibe sonna nyine lan to lafita men ibe wala ibe tamala wala waranto ye tama nyindola.
Well, I can say both were ongoing. Because whilst I was defending the case and the case was ongoing,
I
was equally making efforts to get a nulli or a withdrawal of the case.
Kajoko milialon ko lebe kiti ndrola ya foko sa ebe kiti oni ba bondela kiti bongo kono la e bang.
What was the demand?
Nan kanin roti
in exchange?
Muna falente kuma ku sifa la falente ini tema.
For your compliance.
Pour ye sondi.
in exchange for what you wanted, the knowledge. What was the executive demand?
The first one, obviously, is to compensate the complainant, which is Mr. Sekou Barrow.
Follow minti wala nyinte ko mi ya lonko wole wo borelo nyin nati pour ya neexal ye fen diala.
Which I refused.
Balanta wala.
Because I did not offend him.
Ato ma toñi.
And the second...
Did you cause him any economic losses?
No, I did not cause him any losses at all. Because the property...
So the issue of compensation would not necessarily arise, because a compensation would be for a loss sustained.
Well, his case was about fighting for possession of a piece of land.
Yala tele diamo keta minti wala nyinta abe noma sadara ke kan kenola mi alonko akatel tam.
But then the demand was to give him another piece of land.
That
I should give him another piece of land, which I refused.
Well, he withdrew his case.
He withdrew the case, the complaint, at the police, because my colleagues were there with my family, all descended on him and appealed to him until he agreed to a withdrawal.
I was in fact referring to the withdrawal of the suit. He gave instructions for you to abandon his cause.
With
that, he ought not to be entitled to any compensation.
Well, his demand for withdrawal of the suit has been complied with because it was withdrawn. He agreed in writing to withdrawal of the complaint itself before the court. And when that withdrawal was served on the then DPP, he made a withdrawal of that withdrawal. And then the matter proceeded. But during the proceedings, I must say this, the trial magistrate appealed to me to do something about this case before I will get a conviction.
Was it really an appeal or an advice?
Well, I will say it was an appeal in the sense that he said he did not want to do what he
would be legally obliged to do.
Exactly.
Isn't that really
exactly
an advice to you? My friend, do something. Otherwise, I'll be obliged to send you to jail.
Do something that I don't want to do against my wish.
So you are being advised.
And warned as well.
Exactly.
Well, because of that, I did everything I could.
That advice was not in a vacuum.
Yes.
Tell us precisely what he wanted you to do.
Well, exactly what he wanted was to make efforts to secure a withdrawal of the case before the court.
Alafta min fam fam la wala nyinti ko komi nga kato beke kaje ko nyindi amoni ya bondi kiti bunda nyintole.
Which I tried.
Mi alon ko nga kato kele.
How?
ñaadi
Now, we were talking about the first limb of compensation, which failed, and then the second limb was to comply with the executive.
Komi kuma ku follow ni ngole kacha komi wala kanne hal diamoni yebang. Fula jonga wala nyinti ko komi ka president ni pour ka songala kola isaje ki diamoni
Could you explain that further?
o fanu ni o sada bang faye jam fado man
To comply with the executive.
ka song ni ñaaton ko la kangola
That is to show allegiance
wala kaitan na fasaro kaitandi.
to the president.
President kaitandi nga president fasale.
Was that showing compliance
o mu fulade mi alon ko kay tandi ko e sontale
or to curry favor and lobby the president?
warando ka dani do dani
We have to call a spade a spade.
Yes,
We,
I-
we don't have to win the dress things or sugarcoat them.
I
We call
will-
them by what they
manjara nga
are.
ñiñandi ngi kumandi tola kuma kan ñinga kumanda
The reason why I said compliance,
Nyaje nko pro lafta kan sondi pro sondirola.
what it means to me was to not to defend the cases that I was defending against the state.
Nte fe woko to minti wala nyinti ko nkana lo diamol mi yalan ko wolebe ke kanu kitiyo kono pro
That
nkana
is to
continue
stop
ka lo
defending the cases that I was defending against the state.
wala ka lo diamol ye mi yalan ko mansala dabe wo diamol kono.
Was that condition put to you?
o yo sartol ñing warando o kuma kan ñing ye landi ñaati ngol ban ko ñulle
Was that demand made of you?
fo kanin ro ñing yo landi ñaati ngol la ban
Yeah, it was not expressly mentioned to stop defending cases, but when you are asked to comply with the executive,
bari amanke ko ya fanyele fo safero fon fanala komi ngake bari komi we mi itande wala ni komi nyanta sonnale nyaton koma.
Who told you to comply with the executive?
Jumala
Because
koy fam
that
koy
by
ko
itself does not make much logical sense.
mala fam koy pour yeso ñaaton ko ma ka o kuma kan fam don o mu kuma kandite mi yalon ko skunguta mutanor
You comply with rules.
yeson ika song startol le mi yalon ko be laari
You agree with the wishes of the executive.
yeson executive santon ko la dian ñoo fe ko
You submit or deliver the demands of the executive.
ya fay tandi waranto ya di executive wala santon ko la dian ñi ko la
What were you told?
ite yemuna foyete
the compliance here means to agree with the wishes of the executive.
Ni ko nyin compliance ni wala ka song o koto minti wala nyinti ka
And what
song
were the
ini
wishes of
nyaton ko
the
lesa.
executive?
mun executive nya santon ko la kanin ko de memu la dian ñi ko tije
That is to stop defending the cases in court.
Wala ka ndaha ka lo nyin diamol mi wala be kerin kiti bundato.
Who asked you to do that?
jumala ye kanim fam fange pour ite yo okay
Well, if you don't mind, I can give you the name,
Of course, of
Ni
course.
antara ta mulu ne fe fendi se tol ni
not
dila
on
no.
air.
Nta dile la mol be.
Well, Mr. Mo, don't you think that this is one instance where the name of the person ought to be announced publicly?
Mr. Mboji mamira nyinem di jannam di girare nyimmar nyinto nga to lankene ma fonyo kono
We are trained to be confidential in our job.
Yalong yentol karandi minna wala nyinti ko prunga kullo soto na do ko la fanna.
Well, we are talking about obstruction of justice here.
silan jambe diam kan kulla me yalon ko luwa la ye mari wel tinyaaja
We are talking about interference with the judiciary.
jambe diam kan kula fanan wala mi diga dabulo me yalon ko wala keta kiti bundal la
So don't you think that that situation, in fact, warrants or heightens the public needs to know?
riya mira sai wo ko membe laare wo nyama jaro a jarata le bam puru e kaw ko nyim mabo jamara hamano maba
Well, what the efforts I did were
Could you respond to that?
sorry.
That
Ujabi ba?
the issue we are dealing with
be ko men jube kan ten sainten
involves interfering with
Well,
the with legal processes, with the judiciary,
wala nyindi ko dabulo men ka menke wala kiti bundal toti
and obstruction of justice.
aning fanan ka bandambi de to nyala sabato kan.
Don't you think that these two important violations
Ma mira nyin ku fulol me alon ko nyanta tinyallem
heightens the public right to know
a jareta la bam puru ka jamma ka mabu jamma ma puru ikana lon
who was involved in that?
jummo jumalem me alon ko atela mode men dabo
I stand guided by your wisdom on that.
silande ite sintete o mirror.
See, we have a duty of confidentiality.
On these two important issues?
No, right now, the issue is not about the interference with the judiciary or administration of justice.
The
issue is about a proposed nolly, that is if the request for a settlement out of court is granted.
Coming Mukuati wala nyindiko pruka kit milbe kitindro ke kam pruke sondi ye kitio nyim bondi kiti lata atara ko coming kachakela katala songo katala pru bekachala nyameng ye kolbe landi mirankele.
But isn't that a trivialization of exactly what it is? Because what is being talked about is to fraudulently obtain a nolly.
Atumbe mem fo kanje wala mindi ko ka ku soto mo bulu mi alan ko tapale ya kum wala noliti wala kiti onyin ka bant ka bula pour i kana kitindi
on the basis of a political compromise.
Andu membe ko ma wala mindi ko politiko wala ko nyim beta.
Which is it?
Jumala kilim.
Yeah, firstly, I will not agree with fraudulent acquisition of a nolly.
Okay.
Follow
but I understand why you would not.
Because professionally, we owe a duty of confidence to each other. Confidentiality. Yes.
But allow me to interject on that. But that is only for client and counsel relationship. But
Yes.
this was not a client and counsel relationship, was it? Because there's a technical catch here. And you know it.
Yes.
I don't want to disclose that.
I know.
So this relationship could not have been lawyer-client relationship. So where is the confidentiality?
This is between...
Is it honor between two men? That's what you're trying to say. But it is not legally guaranteed confidentiality or legally protected confidentiality.
No, not legally. This is
honor amongst
honor between two men, yes.
Okay. So proceed.
Yes, but eventually there was a conviction and a custodial sentence. And again, there is an improper exercise of discretion.
Before we get to the conviction, we were talking about two limbs here. That is the political prostitution, quote unquote, and the I dare you to prosecute me. You said you took the first option. That is to go to bed with the executive. And to submit to the demands of the executive. What were those demands?
Well, I just mentioned this, and that was, in fact, I can say that is in summary, but none of these conditions were fulfilled and none of them could be applicable in my case. Because I continued defending my cases.
But in spite of the continued prosecution, did you submit to the demands of the executive?
I tried, but I failed.
Well, maybe you failed to their satisfaction.
Exactly. Yes. Satisfy them.
What did they want from you? You told us to drop the cases you were defending. Was it limited to that? Don't switch me to cross-examination mode.
No, that was not all. Because that's just one of the conditions.
But
and I could not agree with that condition.
What were the other conditions?
Like I said, when I said compliance with the executive is to obey and the wishes of the executive.
I am trying to lead here. So take the cue and come up with the responses. Otherwise, I'll have to switch, change the style of questioning.
It doesn't matter, Council.
Mr. Mboj, wasn't it the case that you are required to support Jammeh?
Yeah, Mr. Mboj, for you manka kuola nyade wala nyide ye kanindro ke bulle pour ye Jammeh ye kala kanun tedi ba.
That's what I exactly said. That's to obey the wishes of the executive.
Let's just answer the questions. I gave you the chance
that
bring them out.
Yeah, that amounts to supporting the executive.
And the support for Jammeh was not just limited to that perceived support or I am now for Jammeh. You had to go publicly in support of Jammeh, correct?
Yes, that is right. That is
and
right.
You had to go and campaign for Jammeh.
That is correct.
And including public appearances for Jammeh.
That is right.
And not only that, you set up a rival bar association
to
become an echo chamber for the wishes of Jammeh. You're smiling, Mr. Booth.
Yeah, I beg to differ on that last point. The rest, I agree with you about campaigning for him. I did. Yes. But setting up a rival bar as an echo.
You set up a rival bar association, correct?
Yes, I did.
And it was based on an advice given to you.
Yes, that is right.
And that advice was based on what was Jammeh's best interest.
Well, I wouldn't agree that the setting up of the rival bar was for the purpose of satisfying the
Wasn't it for the benefit of Jammeh?
No, I disagree with that.
But clearly at that time, Jammeh was not happy with the existing bar association.
Correct. Not only Jammeh, but I myself.
But just answer the question.
Yes,
but just answer the question.
I will explain after my answer.
I'll give you the chance.
I'm doing that now. We can do that concurrently. Yes.
But just allow me to ask.
Yeah, I want to beef up your suggestions. I agree, yes.
Let me ask the questions I want to ask, and then you'll be given the chance to respond.
Explain. Yeah, I want to explain as I answer your question.
Answer the questions first. And because I'm the one.
Then explain. I have that right. And
of course, your rights here would be respected.
Seriously, I believe that.
Yes, definitely.
I believe that.
So Jammeh was not happy with the existing bar association.
Yes, I agree with that.
Okay. And it was important for Jammeh that there was a mouthpiece in the legal fraternity which echoed what he wanted.
Well,
that might be a fact.
And that was important because the voice of the Bar Association need to be counted. By a similar voice.
This time, yes.
Just answer the question.
Yes, but
just
there
answer
is
the
a
question.
but not on behalf of Jammeh.
Just answer the question.
I will answer and explain.
Okay, we would come to that.
We can do it concurrently to save the time and so that I don't forget what I want to say.
I would remind you.
You cannot, because it's in my mind, not in your mind.
Okay. All right. Okay. But the fact of the matter is, Mr. Jammeh needed that mouthpiece to counter the loud voice of the bar. He needed that. You've agreed to that.
That might be the case.
And it was suggested to you to establish that rival bar. You have agreed to that.
Yes, I'll agree to that.
And the person who suggested that to you is a proxy of Jammeh.
Well, I wouldn't say no. I would say yes.
Exactly. So when this person suggested it to you, he suggested it for the benefit of Jammeh.
Maybe at the time, yes.
And you agreed to do it.
Yes, I agreed to do it, not only for the benefit of Jammeh.
Just a moment. But when you agreed to do it, you had the full knowledge that this was mainly intended by the person who suggested to you that this was to benefit Jammeh among other benefits. Correct?
Not all.
Among other benefits.
Not entirely Jammeh's benefit.
But in that case, wouldn't you just accept that you were being used?
I was not being used. Because I have my own reasons.
But you became available for their own purposes.
Not for their own purpose, but for my own.
And what was your purpose?
Thank you. If you are in a situation like a matter before a court, prior to my arrest, it was lawyer Moses Richards. I attended that meeting, to an emergency meeting of the bar, where I gave my full-fledged support to the bar. But after the case of Moses, when it was my turn, I did not get the much needed support from the bar. So where do I stand? I have to take a position. If you don't have the support of your colleagues, and you are in the middle of a case, and it is suggested to you that if you want to get out of this case, this is what you should do. Doing that is not to the benefit of Jammeh, it's to my own benefit. From a different perspective.
Mr. Mboj, we do work here at the TRRC. We are paid for the work that we do.
I agree.
But we are not working for ourselves.
I agree.
You went to work for Jammeh. Set up a rival bar association. We will give you this reward. We would give you a knowledge. Who did you go to work for? We know your objective was to get the knowledge. But it's also a fact that you went to work for Jammeh.
I beg to differ.
Okay, I won't. Look, this
I
is.
beg to differ on that.
But Mr. Mo, you can disagree. But this is basic logic.
No.
You are looking at it to the commission, and we would move on.
You are looking at it from one angle, and that's from the angle of the Jammeh regime.
There are two angles. There are two angles.
If you watch it from both sides and come out with the benefit.
Just hear me out. You have the service provider and the benefit. All right? The service provider requested you to do something. Correct? They were, okay. And you did that for two reasons. To satisfy what they want, so that you can get what you want. You agree?
Yes.
So I'll just leave it at that.
That is not all.
No, the point I want to establish is you were used. Whether there was a convergence of interest or not.
Yeah, you have to look at it from both sides and not from only one side. If you want to do justice,
the fact remains, Mr. Mboj, that they told you go and unscrew the nuts from that wheel. You went and did it. Whether you wanted the driver to have an accident or not, you were procured to do it. You agree?
I agree with that.
Fantastic.
What I'm saying,
fantastic.
You are not looking at it from two angles.
No, but you have just agreed, so there's no point going over this.
No need going over it.
But how did you feel that you are now being used by the executive against your own colleagues?
My colleagues were used before me, against me, before I was used against them.
Without agreeing with you, appearing to agree with you on the first premise. Let us assume, without conceding, that they were used against you. Do you believe that was wrong?
To use your colleagues against you?
To use them against you. Do you believe that was wrong?
To me, it will be wrong, but to those that are being used, it may be right. One man's food is another one's poison. One will benefit and one will suffer.
So you also decided, knowing that this is absolutely wrong, you also decided to do it, knowing fully well that it's wrong.
Not absolute. I'll put that word on quote. I don't like that absolute.
Okay, all right. You knew, or you believed that what they did was wrong. Nonetheless, you decided to do the same thing.
Well, I will say what they decided was for their use and benefit, and what I did was for my own use and benefit.
Selfish, is it?
Selfish.
Machiavellian. You agree with all that?
Well, I wouldn't agree with your Machiavellian theory. Not anything. I don't go to that extent.
Okay. But Mr. Mboj, I'm really sorry that Jammeh used you in the way that he did for you to go against one of the most honorable associations in this country.
I wouldn't agree with that. But
bari
Rather, I would say
mba fola ko
that it was the most honorable association, like you said,
wal mu ding do ku fanale mi
that
yalan ko
failed to protect its own members from the abuse of Yaya whilst defending them.
But
Because my arrest led from the meeting of the GBA, emanated from there.
Okay.
To my severe comments.
But Mr. Mboj, irrespective of how angry the executive was against you, you gave them cause to have you arrested, to have you detained, to have you prosecuted. It was not based on a vacuum. You see, Jammeh was not just angry against you. He was angry against the members of the bar in general. Was that not the case?
Not the bar in general. It is only those who are standing against his interests.
But
it is individual rather than collective.
Were you the only one?
Surely I was not the only one.
There were many others.
Certainly, I agree.
There was L.S. Kamara taking cases against government. There was S.M. Tambedu taking cases against government. There was Nene Cham taking cases against government. There was B.S. Ture.
We were all together.
But none of those were prosecuted because they did not have a cause. So that your prosecution was not just something manufactured out of thin air. You gave them concrete basis.
In response to that, I will simply say there's no man who is infallible.
I know, I understand.
Human.
And Mr. Moj, let's get it clear. I did not even go into who did the thumb printing, because for me, it really does not matter. And I am not interested in whether you are culpable or not. I am not interested in that. And certainly, this commission is not about that. The issue is whether there was a basis, because we're going by the law. The law says when there is a reasonable suspicion that a person has committed a crime, you can arrest the person. Correct statement of law?
That is right.
Okay. Was there reasonable basis to believe you committed a crime?
Yes, I did concede to that.
Exactly. So your prosecution was based on something concrete, and it was based on proper application of the law, regardless of the wishes of the executive.
The conclusion was wrong, with due respect. If you allow me, I'll tell you why.
You see, we cannot sit here and impinge judicial conclusions especially when those conclusions were not appealed. And overturned. Our test of legality here would be that this is the law or this is what the courts have decided.
I can tell you there was an appeal.
Was the appeal overturned?
One by myself.
Was the appeal overturned? Was the decision overturned?
The appeal by my then counsel was against the conviction and not the sentence. Against the sentence and not the conviction.
So in effect, by that you have accepted that you have committed a crime, and the judge have found you guilty.
I denied the charge.
Mansong, tumirol nyinna.
I denied the charge from the beginning.
Okay.
Mr.
Mboj, no.
If you say that I was convicted, yes.
Okay.
Not that I accepted committing an offense.
All right.
I will never commit. I will never accept that in my life.
Okay. I understand the sentiments.
I will never accept that.
I understand the sentiments involved. But what I'm trying to interrogate here is
The commission of an offense insinuates mens rea.
except if it's a strict liability.
Except a strict liability offense. But in none of these cases, there is, which is a strict liability offense. What I'm trying to say is that I never had the mens rea to commit any of these allegations. That is committing a crime. Because I did not forge. All right.
No,
let me not go.
I understand. I understand the points you're raising, Mr. Mboj.
Yes.
But that is far from what I'm trying to say.
Well, in opposite angles, because
What
you are
I'm-
looking
no.
at it differently.
Yes. What I'm trying to show is the court gave you two things: a conviction and a sentence. Do you agree?
Yes, I agree with that.
And the law gave you the right that if you do not agree, you can appeal it.
Which was done.
Correct?
And I have done that.
And you had a choice to appeal against the conviction or to appeal against the sentence or to appeal against both. Correct?
I did that as well.
Just answer.
Yes.
That is correct.
Yeah.
You chose to appeal against the sentence. You did not appeal against the conviction.
That is not correct, Counsel.
Oh, okay.
I did not choose to appeal against conviction. It was Counsel who was representing me that filed an appeal against conviction without appealing against, filed an appeal against the sentence and did not appeal against the conviction.
So what does, okay, first instance, counsel does not act independently. Counsel acts on the instructions of the client. And this was your own case, Mr. Mboj.
Yes.
I would be hard pressed to believe that counsel would just sit in chambers and do the papers and send it without reference to you. You are a senior lawyer. That will not happen.
This is exactly what happened. Because, if you allow me, when I was sentenced, I was denied access to the public. And I could not have access to my lawyer. And all she could do was to appeal against the sentence.
But do you also believe that if there were reasons to appeal against the conviction, the lawyer would have done so?
She never participated in the trial. She's not,
but the record was there for her to study.
Filing an appeal requires you as counsel to go through the entire record so you know where the court went wrong. But in the absence of the records, what is obvious to counsel
Mim saying wo council lawyer nya se min keno.
There is a sentence
Mim say ye
and a
busaro
custodial
la o maro
sentence.
kan. Mari
So
kan
if council decides from the facts before her to file an appeal against sentence,
sa na tala ko min belar nga nyatlu nga nata fa ko abe dundir ke la pour ye senkan jiber ke busarol mi ay wala mari kan.
that was not what I did or what I said in person. It is correct.
Amang ke ko nte fonga wala ke wala nga wala fom fom.
Let's put it this way. The appeal against the sentence
Kambriye dundiro ke pour ye senkan jiber ke.
and failure to appeal against the conviction
Atara yeman dundir ke pour ye senkan jiber ke loi blo le kanyam.
implies
Waya itande ko.
that you had no complaints against the conviction.
Imam fen soto yebe mum fola nyin ko la mi alan ko ye soro wala.
It does not imply that?
No, I don't agree with that.
Man
Because
so
if
wala.
I had, excuse me, there's a serious miscarriage of justice here.
Yeah, je loi tata nyala mi amantani silo.
If I had the opportunity to meet my lawyer,
Na taranga wato soto num pour kan lawyer je.
I would have given her instructions to appeal against both sentence and conviction.
Den numbe ya maro dila praye dundir ke ye senkan jiber ke ye loi blo lanka nyama nim busarol mi.
When I was convicted and denied access to the general public, including my lawyer,
Bar kabri wato min na loi blo lanka balanta pour mol fo nje na lawyer fo dabe
the
wala.
only option that is open for the lawyer was to file an appeal against sentencing.
Lawyer nyinga se min keno doron wala ka sen
That
ka
is what she
dundir ke
did.
pour ye senkan jibero ko ye busarol min lanka.
I would agree with you that
Mbe son ne malako
the denial of
Coming-
access to your lawyer was a violation of your right.
komi balanta pour la lawyer je we ye la nyanto etinya.
And that led to a miscarriage of justice.
Mu fenati mi
let
ko
me just
loi
come.
man
Let
anu
me
loi
just
manta.
come.
Mbatu dorongana.
But we have this procedure
Bani ngani tarambulo soto je.
at mile 2.
Mal tu bundato.
The moment a convicted person arrives,
Wato mi yalan ko momi an lawyer blo la ka futata nan.
you are given the forms
Ka fene dila mi an kaito lem.
for appeal.
Pro ibe dundiri
Which I
kala
have
no mina
done.
ka ye senkan jiber ke lawyer blo le.
I've done that, Kazi.
Mo kele.
I've done
Okay,
that.
just allow me to come.
Mbatu ngana.
So you had the forms, you
Sir.
therefore had the option
Wo kaito nyimbe bulu andu
to
wo kan.
indicate what you were appealing against.
Ise dundir ke no le kaitandi wo kaito kono ilafta mune ye mune senkan jibe ko ta ilo sorondiro kono.
Correct?
Fonde.
They have a form.
Ah,
a
kaito
standard
be
form
bulle fomo.
Yes. And
you are
and
given
you
to
being a lawyer,
Fill, yes.
you knew how to
They are-
deal with these forms.
Ite alon ne nyin kaito nyingi ibe mune kela no la kuoto.
This is a form that is against conviction.
Yala nyimo kaito le
It's a
timi alon
simple
ko.
plain
No,
paper.
it's a form
Mantaras-
against both, actually.
Abe
Both
mo pro
conviction
flow
and
belti.
But the original appeal I filed was against both conviction and sentence.
Te senkan dunduro
Let me
min
explain
dundi
for you to
wala
understand.
ye
So
na
you-
sorongo
you-
aning busaro.
You personally filed,
Ite fongo kundingo.
An
Ye
appeal.
dunduro kele.
In prison.
Pro ya senkan jibe.
and your lawyer also filed
Ite fona la lawyer
an
dunduro
appeal.
Separately.
Pro ka
Separately.
Yes.
anite taman
And they were
kele.
given different numbers.
Sa nata na number de la min man
One
kele.
went before Justice Mbai,
Do tata justice bay nyati
and the
no.
other went before Justice Nkia.
Do tata justice inkia nyati no.
But
then-
because I need legal representation
Atun ko nsilo ta mola mi yalon ko wole be lola nya luara.
to facilitate the speedy process of the appeal,
Buka je ko wo senkan jibero
I
nya.
abandoned the appeal before Justice Mbai that I filed.
Sa nata na bular ke nga senkan dunduro min.
And then
dundi,
we pursued the
Justice
appeal
Mbaila
before
kiti
Justice
dula.
Nkia.
Sa nata na bular nga dunduro min ke Justice Mbaila kiti dula.
But, Mr.
Justice
Boyd,
Inkia.
you are a lawyer,
Mr. Mboj, ite mo loyalty.
a senior lawyer in this
And
jurisdiction.
mo loyal bal for.
I am not a lawyer in prison, Counsel. I am not a lawyer in prison. I cannot defend myself in prison. I have to be defended by somebody outside the prison. So you cannot blame me for the fault of somebody who was acting outside the prison.
I
cannot be responsible for that. And I will never take that responsibility.
You see, Mr. Mboj, I
Yeah,
would
yeah,
not
Mr. Mboj.
wish emotions or tempers to rise.
No, you are directing me to a point that I will never accept. That I appeal against sentence and not conviction. I said I appeal against both.
bondi na sorongo ni na busaro be nga bele du
One,
puya senka.
one last question on that.
Nginin kar kilimbe na ofana.
You personally appealed against sentence and conviction.
Ita fongo kundingo yedundiru ke puya
Whilst in
senka
prison,
jiberke
yes.
Whilst
la
in
busaro anin luaya blo le kamina.
It went before which judge?
Atatra kitindila jumana
Justice
nyate.
Mbaye.
Justice Mbaye.
Justice Mbaye.
And your lawyer appealed against only conviction.
Sentence.
Against sentence.
Ila loya nyana ta dindiro ke busaro mi ya wala kam puya senka
And that
jibe.
went before Justice Nkia.
Wala tatra justice inkia nyate mala.
Who made the decision to withdraw one of the appeals?
Jumale nata kuntundiro ke puye wo senka jiber fulol ni ye kilim bondi bondi.
I did not make that decision.
Mo
But you just told us you decided to abandon the one before in Kia.
Yes. Why? Because if there is, excuse me, Counsel, let me explain. If you have two cases before a court, one you are representing yourself in person,
diam fola soro kiti dulado do bi je mialan ko fongal be lori
and the other you are being represented by a counsel,
and do nyin ye mo so do min lote lawyer
which one will you opt for?
be jumana tala
Obviously, where you are
I
represented.
would go for consolidation.
ba bele kafula nyoma
The records, the form in that is used to appeal in prison is a sketchy one. It is only an appeal against conviction and sentence, but without any particulars.
coming kaito mialan ko ko le dila
It
pour
doesn't indicate. Sorry.
pour kan jibero nyin aka ke sefer sutu net dorong abuka dante kende ke ko mialan ko e be senka ilafta yo le senkan jibe.
So if counsel files an appeal on your behalf, obviously you know, without telling you that the appeal filed by your lawyer is the one that will be given precedence.
Sain ya enyanta ka lonko ni la lawyer e dindiro ke ito yala yalo no ko e bole tala.
No, I don't believe that, Mr. Mboj.
Well, you are entitled to your opinion, but that is my
Mala
view.
wala Mr. Mboy.
And I base it on some important legal principle.
Andunga la ni ko la kamila lonko luala fanale.
The lawyer
Lawyer
is the taxi driver,
atelem taxi driver nyinti.
and the client
Andu miya lonko wolen klianoti.
determines the destination.
Atele ka fo moto nyi nyanta tala dami mafon.
So you,
That is not-
you instruct your lawyer to do what you want him to do.
Ite yamaro di la
See,
lawyer la
you
pa
are
effect
failing
elephant.
again. I did not instruct. You did not hear that. I said I was denied access to the public. You did not hear that, counsel, or you don't want to hear it. You don't want to hear what I'm saying.
No, Mr. Mboj.
Or you have taken a stand and a position that you want to pursue, and you will never reach that conclusion.
Okay.
Because I will never agree with you.
I would leave this point, Mr. Mboj.
I think it will be better.
This is not very significant. All I wanted to show is you made the decision to withdraw, to abandon one of your appeals.
I did not make that decision. I was in prison, and I cannot make that decision.
So when you said you abandoned the case before in Kia, you made a
No,
mistake.
not in Kia,
Before
Mumbai.
Mumbai.
Yes.
When you said you abandoned that one, did you make a mistake?
I did not make a mistake because my lawyer pursued the matter that she filed before Justice Nkia.
But
And I followed that suit because there I am being represented by somebody who can handle my case.
exactly. And this is the point. The one that carried both, you dropped. The one that carried only one, you pursued.
And you don't know why, because I never had access to even the notice of appeal. I never saw it. This is only between the court and my counsel.
Well,
If I had seen that appeal, I would have advised my counsel to file an appeal against the conviction.
Okay.
But I never saw it.
Okay.
So I will not take responsibility for that.
No, okay, we accept.
Yes.
We accept.
Yes.
I mean, and I do clearly regret that you are not given access
To the public.
to
my lawyer.
To your lawyer. Well, yes, you're not giving access to your lawyer. And that is a violation. That's
I'm
a
glad
violation.
that you have recognized that.
But of course, here we do recognize rights. And all we are
But you are trying to blame somebody who is in prison and filing an appeal before a court of law and is being represented by a lawyer, and you are saying, why did you abandon this and then take that? I did not make that choice. I had no choice. A prisoner have no choice.
Mr. Butch, what all we are trying to do is to get the facts.
Thank you very much. And now I think I have made the facts clear.
And be rest assured
Yes.
that we have no interest in any personal interest in these issues. You know even better than I do that in this business, we interrogate the facts dispassionately. And we have a sense of justice to ensure that we bring facts out, regardless of which way they go.
Yeah, but when you present the facts, you try to make a distinction between, obviously, what is right and what is wrong. I know as counsel you can do that, but when your witness disagrees with you, I think you should consider the evidence that is being given to you, but not what you perceive.
But I have not stated any particular opinion here.
Of course, you have done.
What is the opinion?
Please, let's carry on. I think we are past that stage.
I think so.
Yes.
Let's carry on.
Let's save the time of the commission.
Let's carry on.
Please.
That's right. And then you continued to campaign for Jammeh.
I continue to campaign for Jammeh.
Yes.
Ha.
Did he give you what you wanted?
I
didn't talk to Jammeh, and I did not make any request to Jammeh.
But you made. Did you make a request to his proxy? The person on the list you just provided.
I did not make a request. It was like an advice given to me. This is what you should do if you want to get knowledge. And I tried what I could, but could not succeed.
So you did the things they requested you to do?
Not all. I could not comply with
but
all
of the
their
things you were requested to do,
you
publicly supported Jammeh?
Yes, I did.
You campaigned for him?
Yes, I did.
You set up the rival bar association?
That is correct.
And you made pronouncements in the name of that rival bar association, which were supportive of positions of Jammeh.
I wouldn't agree with pronouncements. That statement was not a personal statement. There was a conflicting, I told you that there was a serious crisis which was created at this particular time. And this, if you
was it
permit
created
me,
by the existence of two bar associations?
if you allow me to explain, this was between the GBA, the judiciary, and the Ministry of Justice. All these three were stakeholders in my case. And because I could not get any support from the GBA, and I am in the clause of the executive, and the judiciary should decide my fate.
And with the support of the Ministry of Justice?
Yeah, with the support. But then there was a breakdown even there. There was a serious breakdown between these three stakeholders in my case.
But doesn't that really reflect the depth to which we have fallen? That is the executive, that Yahya Jammeh ran the show. He divided and ruled. You did what he wanted or go to jail. Could secure people to do his bidding. And those who challenge him
ani miliyalon ko ka kunta nyato ala kol
would go 6 feet deep
wal bitale banko duma
or to the 5-star hotel
wala ye tala 5-star hotel oto
or on exile.
wala ye finti banko kan
Wasn't that the case, Mr. Mboji?
fo le man ka quality Mr. Mboji.
Yes, I always agree with you to an extent.
Not ka songi male
100%.
abuka ka be mu meti barin ka songi manon.
Thank you very much.
Because there is always a defense. For me, out of every situation,
Mr. Mboji, you just being a lawyer.
I'm not only being a lawyer, I'm being
Having
practical.
a view or an opinion on everything.
I have my reservations on everything.
But the fact remains
that
this was the situation.
Do
what Jammeh wanted, you survive.
You survive.
You
yes.
don't, you go 6 feet deep. 5-star hotel.
Or you go to the graveyard. Yeah. Oh, graveyard. I agree with you.
You agree with that?
I agree with you on that.
Thank you very much, Mr. Chair. I have no further questions.
Thank you very much indeed, Council, and thank you very much, Mr. Mboji, for coming to testify before the Commission.
Abaraka bake council, abaraka bake Mr. Mboji ilana ajang pour kanela sudiando di nying commission onyati.
I have just one short question before turning to the commissioners.
Nga nyinin kar sutu nesoto lafta kamin kala janimba diamo di la commissioner la.
What was the impact of the establishment of a rival bar association on the Association of Lawyers in the Gambia?
Mune nata ke kolya kulti kabri wato mi yalonko ite nata na nying loya kafu do ba do lo mi yalonka nin loya la wo kafu ba do man killing.
Thank you, Mr. Chair. I
Abaraka Mr. Chair.
appreciate that question very well. The setting up of the rival bar
Dalilo mi yati na ngo kafu do fana londi loya kafu do nying.
is purely based on my reasoning,
My
position,
that
the GBA, that is the Bar Association, when it's being used, fight its own members by the same Jammeh. Because I have records here that can prove that the same GBA, on the instructions of Yaya Jammeh, filed a petition before the General Legal Council to stop me from practicing in this jurisdiction. And when they failed in that attempt, the then Chief Justice, who ruled against them, was fired 5 days after her decision. And that is Justice Ajimang. I am sure my colleagues have mentioned that here. With the executive interference with the judiciary. And that was one of the finest Chief Justice we had in this jurisdiction. But then the issue of segregation is the key problem of the GBA. And if you don't want to be part of them, the law gives me the power and anyone else who is a lawyer to set up your own association. This is a constitutional right, and it is a legal right. And today, thank God, that the law society, which is called the Rival Bar, is growing from strength to strength and giving a different view and a different position in terms of matters that are before the courts. So it is not a bad thing to have a competitor. But we only give options where the GBA cannot do this, and then we provide. And if we cannot do anything, then they can do it. And that is a development of the administration of justice in this country. Because having a single bar in this jurisdiction is a monopoly of the system. And in a democratic state, as ours, everyone have a right to form an association. So what I did was not a legal wrong. It may be displeasing or a moral wrong to others, but it is a right. And that is our position.
Perhaps, Mr. Chair,
In the area, sorry. Yeah, let me just
one
finish
of
this
the
point.
issues on that is the lack of a statutory sanctioned bar association. If that were to be the case, then the legal wrong would come in. And perhaps that is a matter the Commission ought to consider when making its recommendations. Thank you.
Fine, when we get to that point, yes, we will take it into consideration.
Yes, if you
But in
may.
direct response to you, Mr. Mboj,
Yes.
if you are operating in a realm where competition enhances the institution, yes, that is okay. But in an area where you have fraternity is the order, you have competition there, it may not promote that enhancement.
Yes, I agree. If there is fraternity, that is the right choice. But if there is no fraternity, you have an option to break away. And there is, just in response to what Council said, the LPA, which is the Legal Practitioners Act, have made provision for the GBA or any other professional body. You should be a member of the GBA or any other professional body. So it is legal. There is nothing wrong with having another association.
No, there isn't anything wrong to have that. I know jurisdictions where you have rival bars, bar associations, but those are brought about for very different reasons. It's more question of representation than anything else. In any case, were there any attempts to reconcile these wings of the Gambia Bar Association or the fraternity here in the Gambia?
Yes.
What were those attempts? And why did they not succeed?
At the time of the registration, SM Tambidu, who came here, was the president of the bar, the GBA. And he did make attempts and promised to invite me for a meeting which never materialized. And secondly, the current president, which is Mr. Tal, Saliu Tal, also at the commencement of his tenure, made attempts, proposals to meet, to reconcile, but it never materialized. So that is the position.
Thank you very much. One last point from me. I hope your child who had head injuries from the accident recovered.
Njikita ko idingo nying mi alam ko baramata wo accident ngo nyinto anata na jaralo suta kende atal.
Yes, in fact, he was here yesterday.
Kende atal kunum fa benu njane.
But He couldn't make it today, although he wanted to come. He is healed, but the scars are permanent on the head. And he feels shy, very shy about it. Yes.
Well, I feel sorry for him.
Thank you, sir.
Commissioners, if you have any question, Deputy Chair, you have the floor, please.
Thank you, Chair. Thank you, Lead Counsel. Thank you, witness.
Baraka Chair, Baraka Lead Counsel, Baraka Sedo.
Well, you know when two elephants meet, the grass suffers.
Yeah, the name some full bend Nyamoka Badal.
So this was a meeting of two legal luminaries.
Yeah, the Ninkede Bennett Mialanko, Lona Fulem Mianko, a long sort of Luala Fanala.
And we, the poor, non-legal people, had to struggle to understand your arguments. But really, we learned a lot in the process. Thank you. You almost fit the description of the proverbial cat with 9 lives. And by your narrative, you have had near-death, I think 6 near-death escapes.
Yes.
One of which resulted in injury to yourself and to your son that the chairperson has just talked about. With these experiences and that of your other colleagues, how do you assess the position of the state during that time?
Ite wato mansakunda mbenu jang ite yela kuonye nia kotobo kajibe yaje nunyadile
in respect to fulfilling its obligations.
Kata fanala mialonko itol nyanta kuol kala mialonko wole nyantema yesaswal
to the human rights principles of the right to life.
Kata fanala mialonko hadama dingo la nyanto ko hadama dingo nyanta la praya la baluo soto
Liberty
anyanta ka fan soto le
and personal security
ndo fana anyanta tanko soto la fongen
of its citizenry.
ana koma ning banku dingo nyi.
Thank you.
Baraka.
Thank you very much. I understand the question very well, and this is an issue which is very crucial in the Jame era. Which, instead of protecting and defending its citizens, was in hot pursuit of its citizens, to the extent of killing some, maiming some, and sending some into exile. Those who stayed behind have either to remain silent or dance to the tune of the former regime. And I'm sure by this time the Commission have numerous evidence of all those who criticized the former regime. Yes, but just to answer your question directly, the law, which is the Constitution, supreme law, was just there by name, but it was not respected. Because we have seen gross violations of the Constitution. We have seen gross violations of human rights and degrading and degrading situations where citizens are treated with disrespect.
Ndum fanal la fana mialan ko banku dingol fongo ike muta nyala mialan ko fonga nim hormoni mbunya manta.
And we have seen this in almost all the courts.
Andu safa ko mbe njele safa ko dina ka fang dana ka fang kiti bundal be fanal.
To the extent of violating the rights of citizens, to the extent of treating them in servitude.
Kata fang banku dingol la nyanto tinya fa la bang fangay man na bunya soto e fang.
So you have either the option to remain silent or obey or leave the jurisdiction.
Mimbe bul wala nyini ku saba ye sonkola ye sabarakang wala ye dey ni mo no ye finti banko kang.
I hope that answers your question.
Indeed, thank you very much.
Thank you very much. Thank you very much.
Thank you, Commissioner Carr. You have the floor, please.
Commissioner Carr,
thank you, Chairman.
Baraka, Chairman.
Thank you, Mr. Mboj, for your testimony.
Baraka, Mr. Mboj.
As the Deputy Chair mentioned, you've gone through a lot.
Deputy Chair
And I want to know specifically how you were able to rebuild your life, especially after the tragic accident you were involved in.
Lafta ka long inata nila balunino nyadile kabri watu mialang ko ibulata ni accident kolongol kono.
Thank you very much, Mr. Commissioner.
Baraka bake, Commissioner.
Unless I tell the Commission, it will remain a private matter.
For nyaming commissioner wobekele fena de mi abekele ndefangala kullo quality.
The accident has really caused me a lot of financial losses.
Ni accident wa ni keda ayatina la na fanko funa na sato nya Kenya ay batandije bakale ngako di jamale dundije.
And I run into a lot of financial crisis.
Nandana bula kole akul kono ni nata depaso Kenya la.
Because I was able to sustain myself by disposing of my assets throughout the duration of my accident. I went through 4 operations, both in the Gambia and in Senegal, in Dakar.
And in Senegal, Dakar
And I had to pay for all these operations personally. And I had some financial issues, commitments that I could not fulfill. But with the help of the Almighty God, I'm able to sustain myself up to date by relying on my savings and my investments.
Thank you. The second question is, in light of the differences that you have enumerated here in the legal profession, what would you suggest to be the way forward in terms of, let me just stop there. What would you suggest to be the way forward?
Yes, I can say this with certainty. There is a possibility of reconciliation on condition we treat each other as equals and not one above the other. The fact that you are financially in a better position than your colleague, it doesn't mean that you are a way better than him or her. So if we are able to respect each other and support each other, we can work together as a team. But in the current situation, it is difficult unless it is reversed.
Thank you for answering my question.
Thank you, sir.
Thank you very much, Commissioner Kinte.
Commissioner Kinte,
Assalamu alaikum, Lame.
Assalamu alaikum, Lame.
Wa alaikum salam.
Wa alaikum salam.
You have told us that both presidents made attempts at different times.
Ya fonya janko komi ngo president fulol be ye ferol kelenu follow.
Lawyer Sirif Tambedu.
Lawyer Sirif Tambedu.
And presently Lawyer Tal.
And in Sainten Lawyer Tal.
Aren't you thinking of making similar efforts so that you reciprocate their stance?
Yeah, me fana ite ferol fela bang komi tol fana minke fana woke saje fo kuse benno.
In which case, probably you will be able to partner if you will not create a merger. You will be able to partner cordially for the smooth affairs of the law fraternity.
Hana tarafong albe man na kafuno aliyeka kafu kilongoti par koma sembenyo la aliye dogo kenyo kang isaje puru nyeng luwa fana nyeng aseta no tarambul kendola.
Thank you very much, sir. Like I said earlier, it is a possibility of coming together and working together towards the interests of the judiciary
and
the legal fraternity as a whole. But like I said, God has created us, but we are not equal. And we will never be equal. Because we are a step ahead of each other. But when you are at the top, God gave you the chance to be at the top. It doesn't mean that you should look down on those below you or under you. Because if you do so, you never know. Circumstances can change tomorrow. And then things can change. Those at the top can come to the bottom, and those at the bottom can go to the top. But just to answer you directly, it is in our mutual interest to work together and come together as a single bar. But this is going to be very difficult. And this is because of the bitterness in the hearts. Not only myself, but even those on the other side. Going to the extent of filing a petition against your colleague to stop him from practicing as a lawyer. It is going to be very difficult to get that person back into the same society. And that explains my position. So, I don't know whether, like you said, I'll be able to approach them. But time will tell. I think patience and wisdom, we can be able to reconcile the differences. I hope I have answered the question, sir.
Yeah, except that I'm suggesting you come up with some terms that you will put on the table. As I said earlier, that will promote a merger or a partnership, a strong partnership for that matter. Rather than being skeptical about the possibility of reuniting also. And remember, in reconciliation, forgiving or forgiveness is prerequisite. You must always forget or at least forgive to be able to create that environment for reconciliation. And I wish you are thinking in that perspective. Thank you.
I'm grateful, sir, for that.
Thank you. Mr. Mboji, if you have any concluding remarks to make, you may please proceed now.
Mr. Mboji, now that you have come to Labansote, he left a community, so I shall continue no yadi.
Thank you very much, Mr. Chairman, and thank you, my learned friend. We agree to disagree. It doesn't mean that it is personal. I'm so after the commission, you will see us chatting and smiling and laughing at each other.
But
now that you are at the judiciary level, we have issues, serious issues at the judiciary. I know the current Chief Justice is trying everything possible to alleviate those conditions. But we do hope that with the support of the recommendations of this commission, you will lend a helping hand to the judiciary in terms of support, because all they need is financial support. There are numerous issues facing the judiciary. Like yesterday, one question on delay of proceedings. Human resources is crucial, and this is important. So if the commission is willing to make recommendations to support the judiciary with funds to upgrade its systems, especially the support staff. In terms of record keeping and training of judicial staff. This will help a lot. Secondly, there are certain norms and practices in our culture, which I am not sure if it falls within the mandate of this commission. It's more for the Human Rights Commission. But the tradition of slavery need to be seriously addressed. I'm saying so because I am involved in the middle of the slavery cases in the URR.
Katuko nda niaje ngafo nte fongo da bulata nying diamol kono mingi alonko welebe kerim base tundola ni nata jongol la fana.
And as I speak,
there
is a serious security threat in that region.
And niajibe mbediamu kanten sa nyami kanto bunda akade feneti mi alonko kuba da bulaka kono.
And the state needs to address that issue publicly and rather than remain silent.
And
thirdly, I want to appeal to all Gambians and even non-Gambians working with in the government and NGOs. We are losing a lot of valuable time. If I'm taking example from where I work in the courts, people need to respect the time of work, time of break, and time of closing, because they are being paid for it, and from the poor people's taxes. But this is an issue that is a national issue. People, instead of working at 8 o'clock, at 10 o'clock, they are not in the office. At 1 o'clock or 2 o'clock, they are closed. And there is no assistant. And that business is suspended until the next day. And if we keep on carrying over suspended business on a daily basis, it will be very difficult for us to move forward. Well, finally, I wish to thank the TRRC for the wonderful job that is ongoing. And I am confident that the recommendations will be considered by the government, not like other commissions where you pick and choose. And I want to thank my family especially. Of course, my parents, because I'm here today due to the blessing of my parents. Otherwise, I would have been gone a long time ago. And being a reconciliation commission, I wish to make an apology to everyone. You offend some consciously. You offend others unconsciously. But from the bottom of my heart, I'll forgive each and everyone who offended me. And I'm also appealing for forgiveness from each and everyone else that I offended, either consciously or unconsciously. And I thank you very much. That is all.
Thank you very much indeed, Mr. Mboj, for your testimony and for the concluding remarks that you just made. And we are sorry that you had to endure so much difficulty all these years. Thank you very much indeed. Council, you have submissions to make for
yes. There is a protected information sheet Mr. Mboj is requested to sign. And then I'll ask that it be exhibited.
Thank you. Yeah.
This should be Exhibit 216.
216?
Yes, I believe, Mr. Chair. We had 215 yesterday.
Yes, we had them at 215. Okay. That's good. Thank you all very much. And Council, are we ready with the next witness? We can go for another 2 hours.
We'd be ready tomorrow morning, Mr. Chair.
Thank you all very much indeed. And we will resume our proceedings tomorrow morning, 10 o'clock sharp. Thank you all very much. And interpreters, thank you very much.
Thank you.
Meeting is adjourned.